For judgment, item number 1.
Yes.
30th, isn't it, today? 30/10. Therefore, taking into account the specific issue raised in the instant writ appeal and the challenge made to the direction of the learned single judge, and further taking into account the subsequent developments that have taken place, we find that nothing is left in the writ appeal to be examined. Accordingly, the writ appeal is dismissed. It is, however, observed that the dismissal of the instant writ appeal would not mean that the respondents or any of the genuine landowners are debarred from asserting their rights and claims, which, however, should be in accordance with and as may be permissible in law. As we have come to the above conclusion, there will be no requirement to dwell upon the authorities relied upon by the parties.
Obliged, Your Lordship.
We are deeply obliged, Your Lordship.
Item number 2.
Just a minute. This is the wrong judgment. This is not the one. Adiglaw. File dang pakatawa.
For the reasons discussed in the judgment, we are of the view that
The impugned judgment needs no interference by this court. This jail appeal is accordingly dismissed. For valuable assistance rendered by the learned amicus curiae, he shall be paid fees as per the rates applicable to Mizoram State Legal Service Authority.
Deeply obliged.
Give this to me, some signature. I have to put some signature.
My lord, so for item number 7 is concerned, my lord. Then this appeal is admit the RFA, my lord, item 7, my lord. And yesterday we received the paper book, my lord. Yesterday, my lord. Yesterday. So it is in orders column, my lord. So may I pray this matter be come for the hearing column, my lord. In the meantime, we received the paper book, my lord. On 9th of December, I agree with my
Let him
friend, my
call
lord.
first. Items.
Yesterday, my lord. Yesterday I received paper book, my lord. If,
The other side.
other side, my friend is there, my lord.
Yes, my lord, I represent the respondent number one to three.
Have you received paper book?
Yes, my lord.
Who else is there?
State is there.
Have you received? We'll check up the file. Why you not received?
It is already prepared, my lord.
Let the matter be called. We'll see.
My lord, and item number, my lord, 3, my lord. In this case, my lord, last order, my lord, there is appeal is pending, my lord. Writ appeal 8 of 2024, my lord.
3. Item
Item
3.
3, my lord. Yes, my lord. So, my lord, this appeal is pending. Earlier, also, this matter was adjourned with the consent of the other side, my lord. In the meantime, we will also file affidavit, my lord. Required to file affidavit. I'm for Union of India, my lord.
You'll file affidavit position.
I'll file, my lord. I know 3, my lord.
What do you say, Mr. Jonathan?
My lord, I'm for the petitioners in item number 4, which has been clubbed together with item number 3. And regarding the writ appeal he's talking about, I'm the private respondent for the respondents in that writ appeal.
Okay.
Actually, it's a different matter. I don't know why it has been based on that. Why it has been adjourned based on that?
My lord,
There's already an order.
Yes,
from
ma'am.
last time also.
yes, my lord. My lord, what happened regarding the issue of interest under section 28, my lord? That writ appeal is there, my lord. 28. Here also they claiming to 28 interest, my lord. This that's why, my lord, it was. Yeah, my lord.
Okay, counsel for the Mr. Right like this. Mr. S.K. Mehdi Lanet CGC submits that the writ appeal. What is the number?
8 of 2024. Day before yesterday, it was listed before.
Writ appeal 8 of 2024 is not yet disposed of, and therefore the matter may be adjourned. To stop, he submits that he may also be given some time to file counter affidavit. In view of above, list the matter again on 9th of December.
Yes. Yes.
Let counter affidavit be filed by then. Parties to inform the status of the writ appeal as well.
I live.
3 and 4. Yes, call.
Lordship, can I have a message regarding item number 12? I would like to propose the matter be sent to Lok Adalat for settlement.
You're
Because,
for?
the respondent number 1.
What about the appellant? Do
The
they
appellant,
agree?
I talked to the appellant's counsel regarding the sending the matter to Lok Adalat. So, but he said I may need time for time to speak to his client.
So,
So in the meantime, kindly the matter be adjourned for 1 or 2 weeks.
you're there for the other side?
Yes, my lord, I'm for the appellant.
Mr. Kelaldin Liana, learned counsel submits that. No, Mr. Kelaldin Liana, learned counsel for the respondent. Respondents or respondent.
Respondent number 1, Lordship.
For respondent number 1, submits that the matter may be referred to the Lok Adalat. To stop, he however submits that the counsel for the appellant is considering the said proposal, and therefore the matter may be adjourned for 1 week.
Yes, Lordship.
In view of above, matter stands adjourned for 1 week.
Obliged, sir.
Parties to inform the court by the next date as to whether they want the matter to be referred to the Lok Adalat. Yes.
For orders, item number 7.
From GA. Have you seen? You just inquire from your office. Somebody has signed. Please write down. Parties are represented there by the respective councils and they submit that as paper book is duly received, the matter may be listed for hearing. Stop. Next para. In view of above, office to list the matter for hearing as per its own turn.
My lord, on 9th, my lord, December, my lord, because they also, my lord, they have some urgency, my lord. 9th of December, my lord.
I don't know. Can you do all these matters on 9th of December?
My lord, this hearing matter,
You will come on 9th of December and adjourn it to another date.
No, my lord, up to 9, 10, 11, I will be here, my lord.
This is what's happening.
No, my lord, yesterday, my that matter, we received, I was supposed to argue this matter yesterday also, my lord.
Next para. Mr. S.K. Mehdi, learned CGC submits that since the opposite party has urgency in the matter, let the matter be listed on 9th of December 2024, on which date he says that he'll be available.
Yes,
Next para. In view of above, registry to list the matter for hearing on 9th of December 2024.
yes.
Item number 8.
This is state appeal and the matter is handled by Miss Mary. She's on legs right now. So if this matter can be passed over for some time, Lordship.
Condonation of delay, my lord. 1436 days delay. Yes, ma'am. Yes, my lord. Yesterday I returned, my
Oh,
lord.
you have come back.
Yes.
Okay. You have filed your objection.
Yes, your
How much
lordship.
is the delay?
1436, my lord.
Okay, let her come.
My lord.
Or should we list it some other day?
Yes,
Your lordship,
it
yeah.
may be listed after 2 weeks, my lord.
It is submitted by the parties that the pleadings are complete in the IA and the matter may be listed for consideration after 2 weeks. In view of above, list the matter again after 2 weeks.
It's okay.
Item number 9.
You're not audible. You're on mute, perhaps? Mr. Mahajan?
Lordship, this matter also handled by Miss Mary. So if this matter can be passed over.
This is for the first time. It's for the first time.
All right.
What else can be done? Notice will go, that's all. Mr. Mahajan, we cannot hear you. Just find out, is it from that side or from this side? We cannot hear them. No, we cannot hear you. Oh. Probably the problem is from your side. They say this side is okay. We'll do one thing. You just try to resolve the issue. We'll take it up at 2, if you can hear me. At 2.
For hearing, item number 10.
Since this is part hard, so
My lord.
I thought we should give priority to this.
My lord.
May I please, Lordship?
Yes.
Yesterday, I'm in the midst of making my submissions, my Lord. So I'll pick up the thread from where I left off. My Lord, the claimants were at liberty to file as many documents as they want in support of their claims while filing their application.
Antika,
And they have
you may
filed,
go. Both of you may go.
and they have filed the instant application along with the documents, requisite documents, whichever they want, they enclose along with their claim application. And similarly, the opposite parties were given equal opportunities to submit their written statement and file their documents, whichever documents they want to enclose along with their written statement. They have done so. And thereafter, the rival parties were given equal opportunities to produce and examine their respective witnesses. Accordingly, they produced 3 witnesses, claimants produced 3 witnesses and examined before the tribunal, my Lord. And apart from that, they did not ask for more witnesses or additional documents to be submitted. Nothing, no stone is left unturned for them. Whatever is to be done, they have done so. So we have all those documents, relevant documents, along with the depositions made by, adduced by the rival witnesses in the present appeal and prepared the paper book, my Lord. Yesterday, we have read out the 3 witnesses, deposition of the 3 witnesses of the claimants. And my Lord, although I have read them out yesterday, if it is necessary, I may read them again. What I would like to submit to your Lordship is that the the deceased, Lal Nun Hima, as we see from the evidences available on record, he was working as a casual laborer under BRTF. As per certificate that is to be found at page 28 of the paper book, my Lord. The certificate was issued by the BRTF authorities. Page 28 is the certificate issued by the BRTF. This certificate shows that oh, sorry, my Lord. This one was in respect of the wife of the deceased. After his death, his wife was appointed as casual labor, as compassionate appointment maybe. There is another...
Wife of the deceased.
Wife of the deceased, my Lord.
Claimant is the mother.
Claimant is the mother.
Claimant is the mother.
My Lord. And
Why wife is not there?
After 5 days of his death, the death of accident, his wife was engaged as casual paid labor with a higher pay.
By the BRTF?
By the BRTF, my Lord.
No, my question was,
my Lord,
why has not the wife claimed?
That is not known to us.
Basically, it's the mother and the 3 children.
Very true, my Lord. There is no dependency as we,
Also,
as
wife is leaving the minor children and the mother after the death of the deceased. Lordship.
Sorry?
After the death of the deceased, then the wife left all the minor children to the mother of the deceased. Lordship. It's already left.
She's left?
She's left, already left. That's why she's not in the claim application.
That the same is not on record, my lord. We have no knowledge
It's
about
there
that.
in the this claimant's witness number 1 Parmoy. She had narrated that things, Lordship.
Okay.
Maybe it is convenient for the mother to file the present claim application. Otherwise, she was the wife of the deceased was engaged as the casual paid labor with a much higher paid. The deceased was engaged as casual paid labor for rupees 5,100, whereas his wife was engaged for rupees 6,600, as can be seen from the certificate issued by the BRTF. My lord, coming back to the submissions I have made, the deceased Lal Nun Lima was working as a casual labor under BRTF as per certificate and duly issued by the BRTF during his lifetime, earning rupees 5,100 per month under 71 RCC BRTF project Puspa till 18 February 2013. And after 5 days from the date of death of the deceased Lal Nun Lima, his wife Lal Biak Zoli was employed as casual paid labor by the same authorities, 71 RCC project Puspa, between 23 February 2013 to 12 August 2014, my lord, 1 year, earning rupees 6,600 per month, more than her deceased husband. And the appellant claimant, my lord, admitted that her son's death was related to his employment as casual paid labor, as he was detailed for duty on 17 to 2013 for boiling the bitumen to be used the next day. However, she has not submitted claims under Workmen Compensation Act, my lord. I don't know why she did not do it so. And my lord, the claimant, the appellant herein, filed claim application under section 163A earlier. And the same was withdrawn by her and filed the present claim application under section 166. As your lordship knows very well, that there are two provisions. One is 163A, that is no fault liability, and the other one is 166, that is fault liability. Since the claimants preferred to file the present application under section 166, it is required, essentially required for her to prove negligence of the driver or the owner of the vehicle, my lord.
Can you give me the details of 163A?
163A is...
What is the case number? When was it withdrawn?
My lord,
MSCT case number?
I have mentioned in my written statement.
Page 36?
Page 23 is my written statement.
Thirty-six also is WS.
WS of the driver must be, my lord.
Okay, you are talking about WS of...
My
OP
WS of
OP1.
the respondent number 1, owner of the accident vehicle, my lord.
Okay.
Although there is no accident at all, there is no vehicular accident in the present case.
That's page 23.
Page 23 is the written statement.
So where is that case number? 9 of 2017, I think. That page 26.
Yes, my lord. Yes, my lord.
9 of 2017. This was under section
Yes.
173A.
Yes, my lord. 163A.
163A, sorry.
Yes, my lord.
163A. Then liberty to file afresh, but
With
no
liberty
date.
to file afresh.
No date.
in spite of strong objection raised by the present respondent, my lord.
There's no date or date of
No
withdrawal.
date was given here, my lord. Yeah.
Now, the subsequent MSCT case number is 6 of 2018.
Yes, my lord. Here, in the written statement filed by the present respondent, number 1, we have raised objections from starting from page 23. Preliminary objections was raised by us from para 1 to 8 is the preliminary objection, denial of certain avowments, my lord. Number 9, starting from number 9, my lord, the alleged accident causing the death of Lalnun Lima occurred on 17/2/2013, while the instant application is filed sometime in the mid of 2017, which clearly shows that the claimants were not dependent on the income of the deceased. There is no dependency according to us. Further, it is submitted that the wife of the deceased, namely Lalbi Akzoli, was employed as casual paid labor by 71 RCC BRTF Project Puspak on a monthly salary of rupees 6,600 after the death of Lalnun Lima, and that the wife of the deceased was indeed earning more than the deceased as such. There is no dependency on the income of the deceased. And number 10, that surprisingly, the birth certificate of the deceased Lalnun Lima, annexed along with the claim petition, does not bear the date of birth of the deceased, which clearly shows that the birth certificate is a fabricated one and that the claimant is put to strict proof of the same. And number 11, the medical certificate annexed along with the claim petition does not show the time nor the date when the deceased was brought to the hospital. As such, the claimant is put to strict proof of the same. Number 12, that as per the police report annexed along with the claim petition, the alleged accident took place on 17/2/2013 at 4 p.m. as per the FIR filed by S. Parmoi. The claimant, when the truck belonging to the OP number 1 allegedly run over the bitumen, resulting to death of Lalnun Lima, and registered long type PS case number so-and-so dated 18/2/2013 under section 279, 325, 427 IPC. It is pertinent to point out that here that the said police report does not divulge where the accident took place, nor does it state where the bitumen was kept and how the alleged accident actually took place, and whether the driver was negligent in causing the alleged accident. As such, the claimants are put to strict proof of the same.
So you are referring to which police report?
The same police report. The only police report available on record, that is page 9 of the paper book, my lord. Same police report which we have referred to yesterday, my lord.
Okay.
The same one. There is no any other report apart from this.
So I think the main issue to be looked into is whether the claimant has discharged the burden of proving the case of negligence.
Right, my lord.
As required under 166.
My lord.
Whether that was done or not, that is the only issue.
Right, my lord. Very true. So, according to us, there is no negligence on the part of the driver or the owner, and no vehicular accident, as no physical contact between the accident vehicle, I should say, the vehicle, alleged vehicle, and with that of the deceased, my lord, Lalnun Lima. There is no physical contact at all. So the issue of proof of negligence in a petition under section 166 of the Act is essential before a person or his master can be held liable to pay the compensation. Here, I'm relying upon the Supreme Court ruling in the case of Surendra Kumar and another versus Manoj Bisla and others, reported in 2012, Volume 4, SCC 552.
Where's this judgment which was referred yesterday by the appellant? Bring it here.
Para 9, my lord.
Para 9.
Para 9, yes, my lord. Page 555.
Yes.
With lordship permission.
Yes.
Admittedly, the petition filed by the claimants was under Section 166 of the Act and not under Section 163A of the Act. This is not in dispute. Therefore, it was the entire responsibility of the parents of the deceased to have established that respondent number 1 drew the vehicle in a rash and negligent manner, which resulted in the fatal accident. Maybe in order to help respondent number 1, the claimants had not taken up that plea before the tribunal. Therefore, the High Court was justified in sustaining the judgment and order passed by the tribunal. We make it clear that if for any reason the claimants had filed a petition under Section 163A of the Act, then the dicta of this court in Kosnuma Begum would have come to the assistance of the claimants. In the present case, in this Supreme Court ruling also, since the claimants did not prove the negligence of the driver, the claim application failed to get any relief.
What is this Kosuma Begum?
This is also in connection with the accident case. Passed by the Supreme Court again, my lord. Although I have not brought the said ruling with me.
Perhaps it's relating to 163A.
Yes, my lord.
Kosuma Begum.
Right, my lord.
Yes.
And one more ruling, my lord. This judgment and order, which I have just read out, passed by the Supreme Court, has confirmed the ruling I'm referring to right now. This Oriental Insurance Company Limited versus Mina Varial and others, reported in 2007, Volume 5, SCC, page 428, para 27.
This is regarding?
Regarding, my lord, the ruling passed by this honorable court, this Supreme Court, was upheld by the earlier judgment which I just read out. This is also similar situation, my lord. Since the claimants could not prove the negligence of the driver, the claim application could not get any relief. At para 27, my lord. Para 27.
It refers to Minu B. Mehta's case.
Yes, my lord. We think that the law, with lordship permission, we think that the law laid down in Minu B. Mehta versus Balakrishna Ramchandra Nayan was accepted by the legislature while enacting the Motor Vehicles Act 1988 by introducing Section 163A of the Act, providing for payment of compensation, notwithstanding anything contained in the Act or in any other law for the time being in force, that the owner of a motor vehicle or the authorized insurer shall be liable to pay in the case of death or permanent disablement due to accident arising out of the use of the motor vehicle, compensation as indicated in the second schedule to the legal heirs or the victim, as the case may be, and in a claim made under subsection 1 of section 163A of the Act. The claimant shall not be required to plead or establish that the death or permanent disablement in respect of which the claim has been made was due to any wrongful act or neglect or default of the owner of the vehicle concerned. Therefore, the victim of an accident or his dependents have an option either to proceed under section 166 of the Act or under section 163A of the Act. Once they approach the tribunal under section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. But if they proceed under section 163A of the Act, the compensation will be awarded in terms of the schedule without calling upon the victim or his defendants to establish any negligence or default on the part of the owner of the vehicle or the driver of the vehicle, my lord. Since the present claimants, appellants, file their claim application under section 166, they are essentially required to prove the negligence of the driver or the owner of the vehicle, my lord.
Which they have failed to do so.
Yes, my lord. Since they problem with them is there is no the physical contact between the deceased and the vehicle. So it is rather difficult for them to prove the negligence of the driver, my lord. And as we have read out all those deposition of the witnesses, since they, as we have said, there are three witnesses produced and examined by the claimants, appellants before the tribunal. As we have gone through their deposition, they failed to prove the negligence on the part of the driver or the owner of the vehicle. And maybe for one reason or another, they failed to produce and examine the inquiry officer or the one and only eyewitness who walked with the deceased at that point of time. Mr. Laldu Sanga was not produced. It was up to them, they did not produce.
Laldu Sanga.
Laldu Sanga was the one who was working at the relevant time, boiling the bitumen on that particular evening.
Where does his name occur? In the claim?
Judgment and order, my lord, passed by the criminal court, acquitting the driver.
Okay. In the criminal case?
In the criminal case.
That was not produced?
Not produced. And the inquiry officer was also not produced. I don't know why they did not do so, but as I have stated, that we have the liberty to produce and examine whoever witnesses we want, we can produce. As many witnesses we want, we can produce. And all documents also we can produce, like inquiry report, charge sheet, whatever. They have not done so. They were having the liberty to produce, to submit additional documents as well as other documents. They have not done so. So, my lord, taking into account the deposition and cross-examination of the three witnesses of the appellant claimants, it was very clear that there is no proof of the negligence of the driver of the vehicle alleged. And my lord, I would like to take your lordship to the impugned judgment and order passed by the tribunal. It is very long, but it will not be necessary for us to read them all. At page 111, running page is 41. My lord, paper book, page 111.
Yes.
Oh, here also the name of the sole witness, eyewitness was mentioned here in my lord. Para 22, I'm reading just for one paragraph or two, my lord. This is how the tribunal decided the impugned judgment and order, holding that there is no proof of negligence of the driver, my lord. I'm reading with the lordship permission.
Yes.
Para 22. However, the present case is a direct departure from the above case. In this case, there were only 3 witnesses examined for the claimant. Curiously enough, the only eyewitness, as per the evidence, Laldu Sanga, who was boiling the bitumen with the victim, deceased, was not examined for the claimant. No reason was assigned for his non-examination. It is an admitted fact that the OP number 2 had run over the firewood which was used to boil the bitumen. This admission was made by OP number 2 himself. However, he stated that he was unaware of the same. From his admitted position that the OP number 2 had run over the firewood, causing the bitumen to spill on the deceased, ultimately causing his death. However, we must ascertain the negligence of the OP number 2 on the basis of preponderance of probabilities. It can be seen from the evidence that the only police report exhibited in the case was prepared 1.5 years after the accident, and it was prepared by the claimant witness O.C. Longklai PS, who was not even posted at Longklai at the time of the accident. The police report itself did not contain any findings, but it stated that a case has been registered on the basis of written FIR submitted by the claimant. As per the evidence, LP Zomangaya stated that he has prepared his report on the basis of investigation report prepared by the case IO, SI George LH Zava. However, this case IO is not examined, and there is no investigation report produced or exhibited. Here again, no reason was assigned for his non-examination. The evidence that the truck had hit the bitumen is in contrast to other evidence, which stated that the OP number 2 had run over the firewood used to boil the bitumen. The other witness, S.I. Lal Kumsang, was the OC of Buong Klang outpost. He stated that he visited the place of occurrence soon after the said accident, and he testified as to the admitted position stated above, and his conclusion that the cause of accident was due to negligent driving on the part of the truck. He stated that as per his investigation, the bitumen was boiled by the firewood. There was a single firewood which was horizontally placed in the fireplace, which was run over by the truck bearing number so-and-so, resulting to overturning the bitumen plate barrel and thereby causing burn injury to the deceased Lalun Lima. He also stated that the accident occurred at 8:30 p.m. at night. This is in contrast to the claimant's evidence that the accident took place at about 4 p.m.
Who said 4 p.m.?
Claimant Parmoy, my lord. Yesterday I have pointed out this contradictory.
She was not there at the time of the accident.
She was not there, but she said maybe as per the information, she was the one who received information about the incident, that his son got injured and so and so because of the spilling of bitumen, boiling bitumen, my lord. In her...
That was stated in a cross-examination, or what?
Oh, yes, my lord.
Or in chief?
I will show you, lordship. At page 52, my lord. Para 8. Cross-examination, yes.
You can come to the judgment at page 83
80.
or starting from 82, last line.
82, yes, my lord.
She admitted that her son allegedly met with an accident at about 4 p.m. at Boong Klang South.
Right.
Now,
That was from the cross-examination, paragraph number 8, my lord.
where is her evidence otherwise? At page?
Page 52, relevant para, page 52 of the paper book.
52.
Paragraph 8, my lord.
It is a fact that my son allegedly met with an accident at about 4 p.m.
At Boong Klang South, my lord, yes.
Okay.
And my lord, at para 21, page 113 of the say judgment, impugned judgment, it is very difficult to point out the negligence of the driver of the truck on the basis of the evidence produced. Apart from certain discrepancies, the evidence of the police officer only stated that they found the driver to have been negligent. That is how regarding the alleged negligence was decided by the tribunal, my lord.
Paragraph numbers a bit, some discrepancies there.
Paragraph?
The numbering of the paragraphs. You were reading paragraph
Oh, yes,
22. It has gone back to 21.
Yes.
After 22, it should be 23.
Yes, my lord.
After 22 now, it is written as 21.
Right, my lord. Typing mistake must be committed by the clerk. Yes. Repeat it. 22, 21, 22 again. Yes, my lord. That is how the impugned judgment and order was passed. And as we have gone through the depositions of the three reliable witnesses who adduced evidence before the court in favor of the claimant, could not make out the negligence of the driver or the negligence of the owner of the vehicle.
These two judgments which you just referred,
My lord,
was it relied upon by the tribunal?
it was, yes,
It was relied upon.
relied upon.
Where is that? At which paragraph?
Page 29, my lord,
Of the judgment?
of the judgment, my lord.
Inner page.
Page 99 of the paper book, inner page 29, my lord. Second paragraph. The matter came to be re-examined by a 3-judges bench of the Supreme Court in Oriental Insurance Company Limited versus Mina Varial and others, reported in 2007, volumes 5, SCC, page 4 to 8.
It is not 3 judges bench, it is 2 judges bench. Justice C.K. Thakur and Justice P.K.
Right.
Balu Subramaniam. This is also wrongly stated. Then what about Surendra Kumar Arora?
That also referred to by the tribunal at inner page 33, paper book 103.
Okay.
Paragraph 16, my lord. The question again came up for consideration before the Honorable Court in Surendra Kumar Arora and another versus Manoj Bisla and others, reported in 2012 for SCC so and so.
Yes.
Here in this judgment, the judgment which I have pointed out earlier, 2007 judgment, was confirmed.
Correct.
My lord.
2007 judgment was relied upon in 2012.
Right, madam.
So basically, evidence, the negligence was not proved,
My lord.
without which there is no question of awarding compensation under 166.
Right, my lord. And even one of the witnesses, Mr. Lalkum Sangha, stated in his cross-examination the fact that the deceased and the vehicle did not have any contact with each other. The same can be praised, my lord. And on going through the impugned judgment and order, also, my lord, there is no, my assumption to your lordship is there is no valid grounds for this honorable court to interfere with the impugned judgment and order. And I pray your lordship to uphold the impugned judgment and order passed by the tribunal, dismissing the claim application.
Okay.
And which is in line with the ruling passed by the Supreme Court. With that, I can conclude my submission.
Mr. Johnny, anything you want to say?
Lordship, if you allow my,
Yes.
need to have a short reply, Lordships.
Yes.
And first of all, regarding the wife of the deceased, may take Lordship to page 48 of the paper book, page 48. That is the deposition of the claimants, Parmoy, mother of the deceased.
Yes.
No, Lordship, the relevant paragraph is paragraph 7, which is at page 49, Lordship. Page 49, may I read, Lordship, with your permission? That we, the claimants, solely depend upon the income of the deceased Lalnun Hima, whose monthly wage, that is about rupees 5,100 only, and that all the minor children of the deceased are living with me, and I have been looking after them as their mother Lalbi Akzoli left them since August 2014, Lordship. This is the reason why the wife of the deceased is not in the claim application, Lordship.
Yes.
And regarding, Your Lordship, the official lapse of the official procedures, such as the police report, which do not indicate or the findings that rash and negligent driving of the accident vehicle was there. Also, in this regard, I have an authority, if Your Lordship allow me.
Yes. What is that?
2011 SCC, page number 635. Paragraph number 10, Your Lordship. Paragraph number 10.
Yes.
May I read, Lordship?
Yes.
Unfortunately, this court finds that the said well-considered decision of the tribunal was set aside by the High Court inter alia on the ground that even though the complaint was forwarded to SSP Hisar and was forwarded to the SSP Hanu Magard, but none of the office of the SPP Hanu Magard came to provide the proof the complaint. The filing of the complaint by the appellant is not disputed as it appears from the evidence of PW number 3 such and such, who is the assistant complaint clerk in the office of the superintendent of police Hisar. If the filing of the complaint is not disputed, the decision of the tribunal cannot be reversed on the ground that nobody came from the office of the SSP to prove the complaint. The official procedure in matters of proceedings with complaint is not within the control of the appellant, who is an ordinary village woman. She is not coming from the upper echelon of society. The general apathy of the administration in dealing with complaints lodged by ordinary citizens is too far well known to be overlooked by the High Court. In this regard, the perception of the High Court in disbelieving the complaint betrays a lack of sensitized approach to the plight of the victim in the motor accident claims case. The other grounds on which the High Court dismissed the case was by way of disbelieving the testimony of Omit Singh, PW number 1. Such disbelief of the High Court is totally conjectural. Omit Singh is not related to the appellant, but as a good citizen, Omit Singh extended his help to the appellant by helping her to reach the doctor's chamber in order to ensure that the injured woman gets medical treatment. The evidence of Omit Singh cannot be disbelieved just because he did not file a complaint himself. We are constrained to repeat our observation that the total approach of the High Court unfortunately was not sensitized enough to appreciate the plight of the victim. The other so-called reason in the High Court's order was that as the claim petition was filed after 4 months of the accident, the same is a device of grab money from the insurance company. This finding in the absence of any material is certainly perverse. The High Court appears to be not cognizant of the principle that in a road accident claim, a strict principle of proof in criminal case are not attracted. The following observation of this court in Bimla Devi versus such and such are pertinent. In a situation of this nature, the tribunal has rightly taken holistic view of the matter. It was necessary to be borne in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be done by the claimants. The claimants were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt could not have been applied. Your Lordship, in this case, though in the police report, it is true that the findings of rash negligence is not reflected. However, Your Lordship, that is beyond the control of the claimants herein, Your Lordship. So it may not be necessary to reflect each and everything in the police report, since the police report is outside the control of the appellant hearing, Your Lordship.
The tribunal had awarded some money.
No, it's not awarded at all, Your Lordship. It was dismissed.
Now, in this case, which
Yes,
you are
Your
referring to, Parameshwari case, which you just read, I'm reading the facts of this case. The tribunal awarded some amount. There was an accident between two scooters.
Yes, Your Lordship.
Tribunal awarded 1,36,547 with
Lordship,
interest at
yes.
the rate of 9%. High Court set aside that.
Set aside, yes, Your Lordship.
Supreme Court again restored it.
Yes, Your Lordship.
According to the High Court, the complaint was not proved.
Complaint was not proved, Your Lordship, yes.
But the case here is negligence is not proved.
Negligence is not proved, Your Lordship.
In your case, negligence is not proved according to the other side, according to the learned tribunal. It is not a case that the FIR is not proved. They say your FIR was filed, okay. You also FIR was filed.
Yes, Your Lordship. Then,
Nobody denies that FIR was filed.
Lordship.
But then-
Lordship, my learned friend had raised an objection on the police report, wherein the findings was not included in the police report. And that is the reason why I produced this citation, Your Lordship.
That is why I'm saying FIR not being proved is what you have cited in this case, Parameshwari's case.
Yes, Your Lordship.
But your case, the present case, relates to whether the fault has been established or not. Nobody is questioning FIR. Counsel says that, senior counsel says that, okay, a report is there, but it does not say anything that FIR was filed, that's all. It does not say that inquiry was made. On making the inquiry, it was found that the driver of the offending truck was driving in a rash and negligent manner, thereby resulting in the death of the deceased.
Lordship, yes. But Your Lordship, here at para 11, it says that the official procedure in matters of proceedings of the complaint is not within the control of the appellant. He is an ordinary village woman, which says that, Your Lordship, though it may not be reflected in the police report regarding the findings of the rash negligent, because it is beyond the control of the claimants, Your Lordship. And the person who wrote the police report has been called before the tribunal. He had adduced evidence and saying that there is a rash and negligent driving on the part of the truck driver, Lordship. So it cannot be a ground to reject this claim application, Lordship.
Yes, anything else?
Lordship, yes. Regarding the documents, Lordship, my submission is that documents submitted or exhibited before along with the evidence adduced before the learned tribunal were sufficient to make a conclusion that the award should be made in favor of the claimants, Your Lordship. In this regard, I would like to rely on the 2019 2 SCC, 2019 2 SCC, page 186. 186.
Paragraph?
Paragraph number 15. 15 and 20, Lordship. 15 and 20.
15 and 20?
15 and 20. In the 20, 20.1 up to 20.8. Paragraph 15 is at page...
Beneficial legislation.
Yes, Lordship. At the outset, we may reiterate, as has been consistently said by this court in a series of cases, that the act is a beneficial piece of legislation enacted to give solace to the victims of the motor accident who suffer bodily injury or die untimely. The act is designed in a manner which relieves the victims from ensuring strict compliance provided in law, which are otherwise applicable to the suits and other proceedings, while prosecuting the claim petition filed under the act or claiming compensation for the loss sustained by them in the accident. So at para 20, keeping in view the aforementioned principle of law, when we examine the facts of the case at hand, we are of the considered opinion that the claims tribunal and the High Court were not justified in dismissing the appellant's claim petition. In our view, the appellant's claim petition ought to have been allowed for awarding reasonable compensation to the appellants in accordance with law. This we say for the following reason. Firstly, the appellants had adduced sufficient evidence to prove the accident and rash and negligent driving of the driver of the offending vehicle, which resulted in the death of such and such. Secondly, the appellants filed material documents to prove the factum of the accident and the persons involved therein. Thirdly, the documents clearly established the identity of the truck involved in the accident, identity of the driver driving the truck, the identity of the owner of the truck, the name of the insurer of the offending truck, the period of coverage of insurance of the truck, the details of the lodging of FIR in the police station concerned in relation to the accident. In our view, what more documents could be filed than the documents filed by the appellants to prove the factum of the accident and the persons involved therein? Fourthly, so far as the driver and the owner of the truck were concerned, both remains ex parte since inception and therefore neither contested appellants. Lordship, this may not be applicable since it is not ex parte. Fifthly, so far as the insurance is also not applicable since the insurance policy is not there. However, Lordship, fifthly, so far as the insurance company is concerned, they also did not examine any witness to rebut the appellant's evidence. The insurance company could not have adduced evidence by examining the driver of the offending truck as their witness, but it was not done. Sixthly, on the other hand, the appellants examined 3 witnesses and thereby discharged their initial burden of proof of the case. Seventhly, if the court did not exhibit the documents despite appellants referring to them at the time of recording evidence, then in such event, the appellants cannot be denied of their right to claim the compensation on such ground. In our opinion, it was nothing but a procedural lapse which could not be made basis to reject the claim petition. It was more so when the appellants adduced oral and documentary evidence to prove their case and the respondents did nothing to counter them. Lordship, here in this case also, the documents which is required before the tribunal has been clearly specified, and that has been already complied in this claim application, Your Lordships. And besides that, the respondents did not adduce any evidence in order to rebut the negligence which has been formulated before the learned tribunal, Lordship. And the deposition of the driver, which is at page 66, Your Lordships.
Just a minute.
Sure.
Claimants, in this case of Vimala Devi, which you are just relying upon,
Lordship, yes.
claimants have examined 3 witnesses. Who are they?
Lordship. Lordship, at para 9, it was there, the claimants examined 3 witnesses in support of their cases. That's on that much it was reflected, Lordship. And obviously the police and the claimants needs to be examined in order to prove 166 under the MV Act.
Yes. What else?
Lordship, And Lordship, may I take Lordship to paper book, page 66.
66.
66, Lordship. This is the deposition adduced by the driver of the accident vehicle.
Yes.
I am the OP number 2 in the instant case. I am the driver of the motor vehicle bearing number such and such. Under employed of the OP number 1, on the night of such and such, I was apprehended by police personnel due to alleged vehicular accident involving my driving vehicle bearing number such and such on the evening of 17/2/2013 at Bungklang South. On the alleged day, I was driving the said vehicle from Longklai to Vasaikai, carrying rice to be delivered to the Vasaikai godown. While I was running through Bungklang South, some laborers had done construction work of the road by burning bitumen on the roadside. On my return journey, the laborers had deposited a number of logs timber to be used as fuel for burning the bitumen, which caused the roads to be very narrow that I did not hit any person laboring in the area, including Lalnun Lima. That criminal case was filed against me, such and such charge section under such and such of IPC. However, by judgment and order dated such and such, I was acquitted from all charges by the Chief Judicial Magistrate Longklai. That is the exhibit. In the cross-examination, which is at page 68, I drove the accident vehicle from Longklai to Vasaikai. Exhibit C11, which is my driving license. In this regard, I say that I hold a valid driving license at the time of the said accident and I was authorized to drive the said vehicle by OP number 1. I admitted that I ran over firewood used to boil bitumen in the roadside without my knowledge, and I did not know whether I had ran over the deceased Lalnun Lima. I did not stop the vehicle due to the fact that I did not know whether I had run over the deceased or not. I do not agree that I continued to run ahead after the said accident since I do not know I was run over the deceased. It is not a fact that the accident occurred due to my negligence. It is not a fact that the deceased died due to the said accident. It is a fact that I do not know whether the insurance was valid at the time of accident. I do not agree with what police had stated in police report dated such and such. I cannot say whether PME report was correct or not. It is not a fact that the date of birth recorded in medical fitness certificate was such and such. It is the fact that as per the death certificate, the age of the deceased was 26 at the time of his death. I do not know whether the firewood was run over by the front wheel or the rear wheel of the vehicle. Lordship, the evidence adduced by the respondents is very casual in nature. There is no rebuttal evidence. Whatever the question put to him was simply denied. I do not know, I do not know. So in that situation, Your Lordship, the claimants had proved that the accident occurred due to the rash and negligent driving on the part of this driver, Your Lordship. And Lordships, another authority which 2021 1 SCC 2021 1 SCC page 171. Operative is at para number 21.
This is regarding?
This is regarding the preponderance of probabilities, Your Lordship. Equally, we are concerned over the failure of the High Court to be cognizant of the fact that strict proof of evidence and standards of proof like criminal trial are inapplicable in MSCT claim cases. The standard of proof in such like matters is one of preponderance of probabilities. Rather than beyond reasonable doubt, one needs to be mindful that the approach and role of courts while examining evidence in the accident claim cases ought not to be find fault with non-examination of some best witnesses, as may happen in criminal trial, but instead should be only to analyze the material placed on record by the parties to ascertain whether the claimant's version is more likely than not true. So the case has been proved in the light of preponderance of probabilities, Your Lordship. So a strict proof beyond reasonable doubt may not be necessary in the MSCT cases. And lastly, Lordships, that is printed out. Lordship, Criminal Appeal number 1931 of 2023. Lordship, yes.
This judgment which you just read, Anita Sharma,
Lordship,
2021, Volume 1. This was a claim under what provision?
166, Your Lordship. Lordship, that Criminal Appeal number 1931 of 2023. This, Lordship, the operative is at page 3, Lordship, the compilation. Page 3, paragraph number 9. Yeah, may I read, Lordship? Insofar as the claim petition filed by the appellant herein is concerned, alleged negligence on the part of the driver of the tank lorry and pickup van in causing the accident has to be proved. This is a matter which has been considered on the basis of preponderance of possibilities and not on the basis of proof beyond reasonable doubt. It is left to the parties in the claim petition filed by the appellant herein or other claimants to let in their respective evidence, and the burden is on them to prove negligence on the part of the driver of auto, the tank, lorry, or pickup van, as the case may be, in causing the accident. In such an event, the claim petition would be considered on its own merit. It is needless to observe that if the proof of negligence on the part of the driver of the three vehicle is not established, then in that event, the claim petition will be disposed of accordingly. Lordship, here in this case also it says that that has to be considered on the basis of preponderance of probabilities, on the basis of the, not on the basis of beyond reasonable doubts. And Lordship, another is at page 5, which is page 5. This is the award passed by the High Court of Chhattisgarh, Your Lordship, though it is not binding, but it may be persuasive, Your Lordship. Paragraph number 5. Oh, Lordship, paragraph number 5. That is It is settled proposition of law that every civil case is decided on its own facts and evidence without influencing the papers and decision of the criminal case. In such premises, registration of the offense and police investigation is not a condition precedent for awarding the claim. Besides this, due to one reason or another, if the first information report of vehicular accident is not lodged with the police or the same was given at later stage and police neither registered the offense or investigated the same, it does not mean that the right of the victim for compensation who suffered the vehicular accident is washed away. The victim remains entitled for compensation on proving the facts and circumstances regarding such accident and factum of injuries sustained by him. He could not be deprived of such right provided by the Act, although such compensation may be awarded only on proving all relevant facts with all probabilities. Moreover, in the instant case, the factum of the accident has been categorically admitted by the respondent owner of the vehicle in his written statement. There is no need to prove the factum of accident by adducing evidence which has already been adduced by the appellant. In view of the above, the tribunal has committed a gross error in dismissing the claim petition not maintainable for want of filing a FIR, and the same is not sustainable in law. And with my conclusion, Your Lordships, so it is true that the eyewitness Laldu Sanga was not called before the tribunal. Lordship. Then my prayer at this stage is let the tribunal decision may be set aside and remanded back the case to the tribunal so that the eyewitness may be produced before the tribunal, because there is no prejudice to the respondents in that case, because the claimant's mother and the minor children are suffering because of the death of their father, Lordship. So I pray this honorable court to set aside the tribunal order and to remand it back for a fresh trial, Lordship. So, yes, that's all, Lordship.
Come back. I'll dictate the judgment in open court. You be there, Mr. Dika. Stop. Late Lalnun Lima on 17/2/2013 was preparing bitumen instead of preparing, right, was heating up bitumen by using fire logs, by using wooden logs by burning wooden logs. Stop. At that moment, a truck bearing registration number MZ07-0349, driven by the respondent number 2 in the present appeal, and owned by the respondent number 1, in the instant appeal. The previous one you cut it, okay? Driven by so and so, respondent number 2, and owned by respondent number 1 in the present appeal, ran over the firewood which was used to heat up the bitumen. Stop. As a result, the bitumen got spilled upon late Lalnun Lima. Apostrophe S, Lalnun Lima's body, and he was seriously burnt. Stop. While he was being taken to Longklai Civil Hospital, he succumbed to his injury. Stop. As a result, a claim for compensation was filed before the tribunal under section 166 of the MV Act by the appellants. Next para. During the claim proceeding, the appellants examined 3 claimant witnesses who were the appellant number 1, and 2 police personnel, public officer. Stop. As for the opposite party, stroke appellants, they examined 2 witnesses. Who are these 2 persons?
Lordship,
Lalram Chana Chinra and Lal Chunua.
yes, Lordship.
Who are they?
That Lalram Chana is the son of the owner of the OP number 1.
since the OP number 1 could not appear before the tribunal, he authorized his son.
Number one.
Yes,
Number
my
one.
lord.
Yes.
Number two is the driver.
Number 2
2
is
is
the driver.
driver himself.
Who are the son of the owner of the truck involved and the driver of the truck, respectively. Stop. After the rival parties led their respective evidence, the learned tribunal, upon hearing the parties, passed the impugned judgment and award, dismissing the claim of the appellants by holding that the appellants failed to prove the rash and negligent driving of the vehicle involved on the part of the opposite parties, oblique respondents herein. Stop. Hence the instant appeal. Next para. Referring to the grounds taken in the Memorandum of Appeal, Mr. Johnny L. Tauchong, Learned Counsel, submits that as per the investigation done by the police and also the cross-examination of the respondent number 2, bracket driver, wherein he admitted that the vehicle / truck ran over the firewood, which in turn toppled the boiling bitumen, causing serious injury and ultimately leading to the death of the deceased person. The appellants have established the negligence on the part of the respondents, and therefore the learned tribunal could not have dismissed the claim of the appellants. Stop. He submits that due to the accident, from due to the accident, you can sell that again. He submits that the accident occurred due to the rash and negligent driving of the truck concerned, and that a complaint was registered by the police White Longclaw PS case number 12 of 2013, dated 18/2/2013, under section 279/325/427. Stop. In order to prove the rash and negligent driving on the part of the driver of the accident vehicle, the appellants produced 2 police personnel, including the inquiry officer, and that both of them had visited the place of occurrence, and there was rash and negligence on the part of the driver in driving the accident vehicle. To stop that, not only did the vehicle run over the firewood, but did not stop the vehicle. After causing the spilling of the bitumen. Stop. Although the case investigating officer was not examined before the tribunal, but the inquiry officer S.I. Lal Khum Sanga appeared before the tribunal and deposed that the accident occurred due to rash and negligent driving of the driver of the vehicle concerned, and under the circumstance, the learned tribunal ought to have awarded appropriate compensation to the appellants and not dismiss the appeal in the manner it was done. Stop. The learned counsel also submits that the respondents as opposite parties before the tribunal did not lead or have any rebuttal evidence. Stop. Therefore, in absence of any such denial that the accident happened due to the rash and negligent driving of the driver of the vehicle concerned, the respondents are only liable to pay adequate compensation to the appellants. Stop. The learned counsel also submits that when the factum of the accident having happened is not disputed, the filing of complaint and the complaint being brought to its logical conclusion cannot be fatal to the claim made by the appellants, in view of the fact that the MV Act is a beneficial legislation and negligence can be established by way of preponderance of probabilities. Full stop. In other words, unlike a criminal case, the strict rules of proof is not necessary in a claim for compensation under the MV Act. Stop. He submits that although the criminal case filed against the driver of the vehicle involved in the accident ended in his acquittal, but the same cannot affect the claim of the appellants under the MV Act. Since the criteria and the yardstick for establishing the claim is not similar to a criminal case. Full stop. He therefore submits that under the given facts and circumstance, the judgment and award impugned cannot be sustained and the same should be set aside. And this court may be pleased to remand the matter back to the tribunal for consideration afresh. Stop. Next para. In support of his submissions, Mr. Johnny L. Tochong has relied upon the following authorities. Column dash number 1. Parmeshwari versus Amir Chand and others, 2011, 11 SCC 635. Number 2, Kishan Gopal and another versus Lala and others. Next, Vimla Devi and others versus National Insurance Company Limited and another, 2019, 2 SCC 186. Next, Sunita and others versus Rajasthan State Road Transport Corporation and others, 2020, 13 SCC 486. Next, Anita Sharma and others versus New India Assurance Company Limited and another, 2021, 1 SCC 171. Next. Oriental Insurance Company Limited versus Raj Rani and others. 2022 SCC online P&H 3673. And last. Matthew Alexander versus Mohammed Shafi and another. 2023 INSC 621. Next paragraph. Mr. L.H. Anshima, Learned Senior Counsel for the respondents, on the other hand, submits that the alleged date of accident is 17/2/2013, and which in fact is a Sunday. Stop. There is no dispute to the fact that the deceased person was engaged as a daily paid laborer by the BRTF, and that Sundays are observed as holidays. Full stop. It is therefore surprising that the deceased person was working on a holiday. Full stop. He further submits that although the alleged accident was said to have happened on 17/2/2013, the police report was only prepared on 12/5/2015, after almost 2 years. Stop. This apart, the police report does not contain any finding to the fact that there was negligence on the part of the driver of the truck involved in the said accident. To stop. The Learned Senior Counsel also submits that the appellants initially filed a claim for compensation under Section 163A of the MV Act, and the same was registered as MSCT case number 9 of 2017. Stop. However, for reasons best known to them, and despite strong objection made by the respondents as opposite parties in the claim, the said claim application was withdrawn with liberty. Stop. Thereafter, the appellants filed MSCT case number 6 of 2018. That is IE. No, you cancel that. And IE, you cancel that. Thereafter, they filed MSCT case number 6 of 2018 under Section 166 of the MV Act. claiming compensation against the respondents on fault basis. Stop. The appellants had all the opportunity and liberty to adduce the evidence of their choice. And after the same was done, the learned tribunal, upon due consideration of the case projected by the appellants, dismissed the claim application. For want of proof of rash and negligence act on the part of the opposite parties, stroke respondents. Stop. The learned senior counsel submits that unlike a claim under section 163A of the MV Act, a claim under section 166 of the same act is with a burden on the part of the claimants to establish the negligence of the driver or the owner of the vehicle concerned involved in the accident. Stop. The appellants therefore, having failed to discharge the burden of establishing the rash and negligent act on the part of the driver of the vehicle concerned, the learned tribunal rightly dismissed the claim of the appellants. Stop. Therefore, the impugned judgment and award may not be disturbed by this court, but upheld. Stop. In support of his submission, the learned senior counsel relies upon the following authorities. Number 1, Oriental Insurance Company Limited versus Meena Varial and others, 2007, 5 SCC 428 and Surinder Kumar Arora and another versus Manoj Bisla and others, 2012 4 SCC 552. Next para, I have considered the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the authorities relied upon by the parties. Stop. There is no dispute to the fact that the claim made by the appellants is one under Section 166 of the MV Act. Stop. The admitted position in law is that a claim under Section 166 of the MV Act is a claim for compensation on fault basis. And the requirement or burden on the part of the claimant concerned is to establish that the accident occurred on account of the rash and negligent driving or act on the part of the opposite party. While driving a motor vehicle. Stop. The appellants, as already stated, led their evidence by examining 3 witnesses. Stop. CW1 is the appellant number 1 and mother of the deceased person. Stop. In her examination in chief, she stated that her son was aged 26 years at the time of his death, and he was earning a monthly wage of rupees 5100. Stop. That on 17/2/2013, her son met with an accident while he was preparing bitumen by using fire. Stop. One vehicle, bracket truck, bearing registration number MZ07-0349, driven by the respondent number 2 and owned by the respondent number 1, ran over the firewood which was burning and causing the spilling of the bitumen over the body of her son. Stop. As a result, her son sustained first-degree burn injury on 90% of his body. And he succumbed to his injury. Stop. She and the 3 children of her deceased son were solely dependent upon the monthly wage of her late son, and therefore the tribunal may award appropriate compensation to them. To stop. She also stated that she lodged a complaint on the same night of the incident at Bungklang South Police Outpost to take necessary legal action, and accordingly Long Klai Police Case PS Case number 12 of 2013 dated 18/2 of 2013 was registered. Next para. No, same para, sorry. She then exhibited the documents annexed to the claim petition, such as the police report, death certificate, birth certificates of the children of the deceased, and the documents of the truck involved in the accident. Next para. In our cross-examination, the appellant number 1 reiterated what she had stated in her examination in chief. And besides that, she stated that it was a fact that the accident happened at about 4 p.m. at Bungklang South, while her son, along with one Sri Laldu Sanga, were on duty. Heating up the bitumen. Stop. She also stated that she was informed by Sri Laldu Sanga that the accident vehicle ran over the firewood used for boiling the bitumen, which caused the bitumen to spill over the body of her late son. Next para.
Lordship may interrupt. Lordship, if your Lordship allow me, please reflect the page 54 in Lordship, cross-examination. Paragraph
Yes.
number 3, page 54. This is a continuation of the cross-examination of the claimant witness number 1.
On being further cross-examined by the counsel for the respondent number 2, appellant number 1 stated that she did not agree to the suggestion that the cause of the vehicular accident which resulted in the death of her son was not due to the negligence of the driver of the truck. Next para. The appellants examined one Sri LP Zaumangaya. What is he? He's police.
Yes, your Lordship.
What rank?
Yes, he's the police,
Rank?
the one who prepared the police report.
What is his rank?
Rank
Constable
is,
or SI? Havildar? What?
SI, your Lordship.
Where is that?
It's in the
Page 9.
Yes. Yes, your Lordship. Inspector. Inspector, not sub-inspector.
But this is in 2015.
Yes, your Lordship. At the time when he prepared the police report, he was an inspector.
Was he the OC in charge? Officer in
Yes.
charge?
At that time, your Lordship, when he prepared the police report, he was an officer in charge.
No, at the time of accident.
No, he's not.
What was he?
At the time of the accident, he was in another posting, another place.
Okay, what did I say? Zaumangaya, who issued the police report dated 12/5/2015. As the officer in charge of Longklai Police Station. Full stop. It may be seen that he was in the rank of inspector of police, but when he deposed before the tribunal, no, what was his rank before the tribunal?
Lordship, rank was not mentioned. It was
From what you cancel that, okay? He was in the rank of inspector at the time of preparing the police report. That much. Full stop. In his examination in chief, he stated that he was aware about the case since the charge sheet was submitted through him. Full stop. He prepared the police report dated 12/5/2015 based on the investigation report. And that he believed that the investigation report prepared by S.I. Zava was genuine. Full stop. He stated that based on the investigation report submitted by S.I. George L.H. Zava, the cause of accident was purely negligence on the part of the driver. Stop. He visited the place of accident after the said incident, and he found that the deceased had prepared the bitumen at the corner of the road, and as such, he can safely say that there was negligence on the part of the driver who drove the accident vehicle. This visit of the site was after how many? Was it immediately or after?
1.5 years.
Okay.
But Lordship, here in that re-examination, he said that no geographical changes of the location of the spot. So,
Stop. It may be noted at this stage that CW2 apparently had visited the place of accident after more than a year of the accident, which happened on 17/2/2013. Next para. In his cross-examination, CW2 stated that he was posted at Lungle as second OC at the time of accident, that is in the year 2013. And thereafter came to be posted as OC Longklai sometime in the month of October 2014. Stop. He also stated that it was a fact that he visited the place of occurrence after his posting at Longklai, that is after more than 1.5 years of the accident. Stop. Further, when he went to the place of accident, he could not see any reminiscent of the accident. He further submitted that the police report that he prepared and which was exhibited as Exhibit C-5 was solely on the basis of the investigation report and its documents. Which were otherwise not annexed to the case record. He also stated that the investigating report and the case record was with him, even though he had been transferred from Longklai. Stop. As per the investigation report, the truck had hit the boiling bitumen, which overturned and burned the deceased in the process. Stop. He admitted that he was neither the inquiry officer nor the investigating officer in the accident, and that he was only the person who received the investigation report for onward action. Stop. On being re-examined by the counsel for the appellant, he stated that he visited the place of occurrence, and at that time there was no geographical changes of the location of the spot of the accident. Next para. Okay, we'll continue and at 2. It's already 1. Oh, there was that bail application, isn't it? Let's just see to this first. PP is ready. Yes, Mr. Mahajan.
My lord, sorry for the inconvenience in the morning, my lord. My lord, here, my lord, with all respect and forbearance, my lord, here is a case, my lord. During investigation is a 60-day period, my lord, 187 BNSS, my lord. Here, my lord, the sections attributed are, so far as the FIR is concerned, my lord, section 420 and 403 and read with, my lord, negotiable instruments act, my lord, which is a non-cognizable offense, my lord, meaning thereby payment of money, my lord. And now here what has happened, my lord, we filed 2 bail applications, my lord, but the outcome we have not come to know as yet, my lord, although we applied for certified copies, and that document we have annexed with our application, my lord. And the other development is, my lord, meanwhile, exactly on the 60th day, my lord, the investigating agency has filed charge sheet, my lord. Now we are seeking bail primarily on 3 counts, my lord. Of course, today is day 1, my lord. Definitely the LCR and all those are necessary, my lord. And the grounds on which you are seeking bail are, my lord, with all respect, my lord, the grounds of arrest, my lord, as provided, my lord, as is envisaged by Article 22(1), my lord, and the latest case, my lord, with all respect, my lord, Probir Pulkayasta, my lord, that has not been provided to us, my lord.
Okay.
And my lord,
Yes, just a minute, Mr. Mahajan.
I'm sorry, my lord.
Did you say that you have applied for bail in before the lower court?
Yes, my lord. On 1/8/2024 and 6/9/2024,
What
and
happened?
we have made categorical statements that, my lord, we file, we move, the outcome we do not know, and in such a given situation, my lord, if it is necessary, my lord, with all respect and forbearance, my lord, the apex court has clarified, my lord, my lord, a higher court can be moved, my lord.
Where is the detail of the bail application?
Yes, my lord, that I am pressing, my lord.
Paragraph?
My lord, with all respect, my lord, my lord. Para 5, my lord. Para 5, I'm reading it out, my lord. Page 5 also, my lord. Para 5 is in page 5, my lord.
Yes.
May I read it, my lord?
Yes.
That the accused petitioner beg to state that on 1/8/24, a bail application bearing bail application number 895 of the 24 was moved in the court of the learned Chief Judicial Magistrate Aizol on behalf of the accused petitioner. And on the same day, the learned court below was pleased to fix 6/8/24 for bail hearing. That thereafter on 6/8/24, the counsel for the accused petitioner again moved BA number 854. I'm sorry, my lord, 895 of 24. Before the land.
Just a minute. This is the same number, 895.
Same, my lord, because when it is landed lower court below, my lord, if CGM, my lord, we file an application, the number remains the same, my lord.
Number will remain the same.
We move, yes, my lord. On 2 counts, we move the bail application, same bail application, my lord. Language and tenor is little bit, we are mistaken, my lord, definitely, my lord.
No, how can you move the same bail application by the same number?
Because possibly, my lord, in CGM court here in Guwahati, my lord, if you file a bail application, if it is numbered, my lord, that then the bail application, if case diary is called for, my lord, that remains still disposal, my lord. The same number, my lord. Same bail application, my lord. The number would be the same, my lord.
Okay, we'll issue notice at this stage.
My lord, can I make a prayer? Yes, my lord, definitely notice, my lord. Can I make a prayer, my lord? Because we have sought for default bail and the grounds of arrest were not provided. Can my lord, with all respect, my lord, the original LCR be sought for? Because the signature of the learned magistrate is a must, my lord, to determine the date on which charge sheet was submitted, because we have sought default bail also, my lord.
The charge sheet has been filed?
Yes, my lord. We have categorically exactly on the 60th day, but that has to be received by the learned magistrate. There is an authority of our own High Court.
No, we'll call for a scanned copy of the charge sheet.
My lord, my lord.
Who's the PP appearing today?
My lord, I am appearing, but then I have some problem with the connection, my lord.
Okay, we'll issue notice. You produce the case, you produce the scanned copy of the records?
LCR, my lord.
LCR by the next date?
Yes, my lord.
And the charge sheet, my lord, with all respect, my lord.
Of course, the charge sheet will be there in the LCR.
LCR, my lord, would be different possibly, my lord. Charge sheet would be different, my lord. LCR will be lower court record, my lord, that those and dates and everything that we file bail application.
No, the
Then
LCR
wise.
the LCR would consist of the charge sheet also, perhaps.
Possibly, my lord, charge sheet would be different documents because it was filed subsequently, my lord.
All right. Heard Mr.
BK Mahajan, my lord.
BK Mahajan, learned counsel for the petitioner through VC, who submits that the petitioner, by filing the instant application under section 483 of the Bharatiya Nagarik Suraksha Sanhita, 2023, prays for enlargement on bail. He submits that the petitioner was arrested on 26/7/2024 in connection with C and EO Police Station case number 1 of 2024, registered under section 420/403 of the Indian Penal Code and also under section 138 of the Negotiable Instruments Act, 1881. Next para. The learned counsel further submits that charge sheet has already been filed by the investigating agency and the petitioner had also moved bail application numbers 895 of 2024 on 1/8/2024 and as well as on 6/8/2024 under the same registration number. However, the outcome of the bail application is not known to the petitioner. Nevertheless, the petitioner, in view of the settled law, is not debarred from filing the instant bail application. Next para. In view of above, issue notice returnable by. When can you be produced, Miss Mary?
96. My lord, if a week's time is given, I would be obliged, my lord.
4 weeks time is a too long time.
1 week time, a week time, my lord.
Okay, a week's time is okay. In view of above, the issue notice of motion. Notice returnable by 7th of November 2024.
Fine.
Miss Mary L. Kyangte, learned additional PP, accepts notice on behalf of the state and therefore no formal notice is required. However, the petitioner shall furnish requisite extra copy of the bail application to the learned additional PP if not already done. The learned additional PP shall produce a scanned copy of the case record, which should also include a scanned copy of the charge sheet by the next date. List again on 7th of November.
Right.
Deeply obliged. Deeply obliged.
Okay.
Hello.
Okay. Now back to the dictation. So, next paragraph, you write, the appellants examined Lalkum Sanga, Sri Lalkum Sanga, as CW3. In his examination in chief, CW3 stated that at the time of the accident, he was posted as officer in charge at Bung Klang outpost and he was and he is well acquainted with the facts and circumstances of the case. Stop. He visited the place of occurrence soon after the incident, and during inquiry, he found that the deceased, along with his friend, had prepared bitumen by using fire at the extreme corner of the road. Stop. From his investigation, the driver of the truck had run over the firewood, which was burnt to heat up the bitumen, and as a result, the deceased was burnt by the bitumen, causing his death on account of burnt injuries on his body. By the way, who is this person? He's the OC.
Is the OC at the time, Lordship.
OC at that time.
Yes, yes. And who had done inquiry.
He had done the inquiry.
Yes.
But where is the inquiry report?
Inquiry report is not annexed here, Lordship. Only the police report was there.
Stop. In its cross-examination, CW3 stated that it was a fact that the accident took place at 8:30 p.m. and that he was sure that it was at night. Stop. The accident report was verbally made to Bungklang South Outpost, and GD entry was made, and thereafter the place of occurrence was visited. Stop. However, while at the time of visiting the place of occurrence, both the victim as well as the vehicle were not on the spot of the accident. Stop. He further stated that although SI George LH Zava was the investigating officer to investigate into the accident, he was in charge of Bungklang South Outpost, and as such, he had visited the place of occurrence. And made entries in the case diary, which was forwarded to Longklai Police Station. To stop, he also agreed to the fact that the only police report that was available on the record was the police report dated 12/6/2015. Prepared by Inspector LP Zaumangaya. Next para. Sri Lalram Chana Chinza was examined as the OP witness number 1 to stop. He is the son of the owner of the truck involved in the said accident. To stop. In his examination in chief, he stated that as he was not present on the spot of the accident, he does not know as to how the accident took place. To stop. The vehicle was sent to deliver rice at Vasaikai go down, and it came back safely. Next para. Sri Lal Chungnunga was examined as OP witness number 2, and he is the driver of the truck which was involved in the said accident. Stop. He stated that on the night of 17/2/2013, he was apprehended by the police personnel due to the alleged vehicular accident which he drove on that day from Longklai to Vasaikai, carrying rice to be delivered to Vasaikai go down. Stop. While he was running through Bungklang South, some laborers had done construction work of the road by burning bitumen on the roadside. Stop. On his return journey, the laborers had deposited a number of logs, timber, to be used as fuel for burning the bitumen, which caused the road to be very narrow. Stop. He did not hit any person including the deceased person. Stop. Criminal case was filed against him, but he was acquitted from the charge. Stop. In his cross-examination, he admitted that he ran over the firewood which was used to boil bitumen in the roadside without his knowledge. Stop. He did not know whether he had run over the deceased Lalnun, the deceased person, and he did not stop the vehicle, as he did not know whether he had run over the deceased person or not. To stop. He also stated that it was not a fact that the accident occurred due to his negligence. Stop. Next paragraph. From the evidence led by the rival parties during the claim proceeding, it can be seen that the only police report that was relied upon and exhibited as Exhibit C-5 was the police report dated 12/5/2015, prepared by Inspector L.P. Zomangaya, officer in charge of Longklai Police Station. Stop. The evidence on record shows that the said inspector was not the officer in charge of Longklai Police Station at the relevant time of the accident, but was posted there after about 1.5 years of the date of the accident. Stop. In his deposition before the tribunal, he stated that the information that was gathered by him was based on the verification report investigation report submitted by SI George L.H. Zava. Stop. However, neither the investigation report nor the author of the investigation report were produced and examined during the claim proceedings. Stop. As already stated in the preceding paragraphs, that a claim under Section 166 has to be established by the claimant concerned. by showing that there was rash and negligence action on the part of the person driving the vehicle concerned. The driver of the truck who was examined as OP witness number 2 in his deposition, during cross-examination, admitted that he ran over the firewood which was used to boil bitumen in the roadside, but the same was without his knowledge. Stop. He also stated that he did not know whether he had run over the deceased person or not, and for which he did not stop the vehicle. Stop. He also stated that it was not a fact that the accident occurred due to his negligence. Stop. The deposition of the OP witness number 2, according to the appellants, only shows that the accident had happened due to the rash and negligence of the said witness. But as already stated, although the police case was registered and subsequently criminal trial number 15 of 2013 registered and proceeded against the said driver. But however, the said witness came to be acquitted. From the charge leveled against him. White judgment and order dated 13/2/2014, rendered by the Learned Trial Court, that is Chief Judicial Magistrate, Longklai District, Longklai. Next para. Reliance has been placed on the case of Matthew Alexander Supra, by the learned counsel for the appellants to contend that negligence can be proved even by only on the basis of even on the basis of preponderance of probabilities and not on the basis of proof beyond reasonable doubt. The said decision is in respect of the standard of proof to be applied by the tribunal while considering a petition for compensation for death or injury in a road accident. The fact, however, remains that the alleged negligence on the part of the driver of the offending vehicle has to be proved. And if the proof of negligence is not discernible, the tribunal will have the liberty to consider and dispose of the claim petition under the given facts and circumstances of the case. Stop. In the present case, although there is no denial on the part of the rival parties that death was caused, that the deceased had expired because of spilling of bitumen on his body and he having sustained grievous burnt injuries. But the fact remains that apart from the lone police report prepared by an inspector who otherwise was not posted in the concerned police station at the relevant time. And based on the investigation report, which again was not exhibited or produced during the claim proceedings. Stop. The standard of preponderance of probability may be there to show the cause of the death, but insofar as the negligence of the driver is concerned, the same cannot, in the considered view of this court, be said to be discernible. Stop. Reliance has also been placed on the case of Oriental Insurance Company Limited versus Raj, Rani and others, Supra, by the learned counsel for the appellant to contend that MV Act being a welfare legislation enacted by the Parliament to provide relief to persons suffering from injuries in motor vehicle accident, strict rules of evidence and procedure are not applicable. Stop. The fact, however, remains that whenever an accident happens and a claim petition is filed before the tribunal, the party concerned has the liberty to avail for a claim under no fault basis, which is under section 163A, and a claim under section 166, which is on fault basis. Stop. The difference between the two claims is that the fact of there being accident being shown and established would be ordinarily sufficient to get some benefit of compensation under section 163A. Stop. However, when a claim is made under section 166 of the MV Act, party concerned has to show that there was negligence on the part of the offending vehicle in driving the vehicle concerned. Stop. In the process of establishing such negligence, the strict proof as may be required in a criminal case will not be required. But nevertheless, the party has to show by cogent and reliable evidence that there has been negligence on the part of the offending vehicle through the driver or the owner. Next para. Proceeding further to the other authorities relied upon by the learned counsel for the appellants, we may see that Mr. Johnny, you had relied upon this 21. Which paragraph? 2021.
2021, what SCC, Lordship?
2021.
21. Paragraph number 21.
In the case of Vimala Devi and others, Supra, the apex court, while observing that the MB Act is a beneficial legislation and the object of the Act is to prevent or reduce the period of pendency of the claim and quicken the process of determination of compensation amount. came to the conclusion in the given facts of that case that the tribunal and the High Court were not justified in dismissing the claim petition. Full stop. However, it was also observed that such dismissal was not warranted since the appellants had adduced sufficient evidence to prove the accident and the rash and negligent driving of the driver of the offending vehicle, which resulted in the death of the deceased. So what would amount to sufficient evidence for proving that the accident happened due to the rash and negligent driving of the driver concerned would depend upon the facts and circumstances of each case. Stop. In the present case, the evidence led by the claimant stroke appellants in the absence of any investigation report being produced during the claim proceeding and also the IO concerned who authored such report would only be deficient to establish that there was rash and negligent driving on the part of the driver who drove the truck concerned. Next para, the materials on record goes to show that the deceased person at the relevant time was engaged in heating up the bitumen along with a fellow co-worker, namely Sri Laldu Sanga. Stop. He was examined as PW7 in criminal trial number 15 of 2013. His deposition recorded by the trial court in the judgment of acquittal was that he worked with the victim at the time of the incident when he was in the downside of the road. The vehicle driven by the accused person came and touched the boiling bitumen plate boiled by the victim. And without caring and stopping the vehicle, he drove the vehicle ahead. Stop. On the way to Longklai Civil Hospital, the deceased person succumbed to his injury. To stop. He was, however, not examined in the before the tribunal. And the learned tribunal in coming to its finding that there was failure on the part of the appellants to establish the case of rash driving and negligence of the driver concerned. At paragraph number 22 and 23 of the judgment and award held as follows. Please abstract A to A, page 111 and 112. Till 113. There's a yellow flag. Next para. From the above abstract, it may be seen that the learned tribunal had taken into consideration the evidence led by the parties in coming to its conclusion that the claim under 166 of the section 166 of the MV Act could not be established by the appellants stroke claimants. Stop the reasoning in the considered view of this court is only acceptable of the apex court in Oriental Insurance Company Limited versus Nina Varial and others, Supra. In the given facts of that case held that once a party approaches the tribunal under section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. Stop. However, if one proceeds under section 163A of the MV Act, compensation will be awarded in terms of the schedule without calling upon the victim or his dependents to establish any negligence or default on the part of the owner of the vehicle or the driver of the vehicle. Stop. The claim in the instant case, as already stated, being one under section 166 of the MV Act, the appellants, on the basis of materials available on record, cannot be said to have established or discharged the burden required under section 166 of the MV Act. Stop. The learned counsel for the appellants has prayed for a remand and for a chance to produce the eyewitness. But however, same is not the prayer made. However, such an opportunity was never deprived. However, the appellants were never debarred from producing such evidence at the relevant time. Stop. Therefore, upon overall consideration of the case in its entirety, this court is of the considered view that the appeal has no merit and the same should be dismissed. Stop. Accordingly, the appeal stands dismissed.
Obliged.
For admission, item numbers 1 and 2.
Please, Your Lordship.
Dika, then both of you may go. Yes, Nari.
I have 3 prayers here, Lordship. Number 1, the respondent number 5 and 6 be directed to release the deducted 10% cess to the petitioners. And number 2 is to make assessment of interest from the date of possession in terms of Section 80 of the Right to Fair Compensation. And number 3, here I have asked for the market value of the lands. Here we have the state respondent has to appoint the authority in accordance with Section 50 and 51 of the Land Acquisition Act 2013. That is my prayer here, Lord. And the first prayer says, Your Lordship,
Yes.
the respondent authority, particularly MADC, Mara Autonomous District Council, has framed kindly section, annexure, Your Lordship, annexure.
Regarding cess,
Set.
let us see what is the provision.
Provision, yes, that is in annexure 5. The
Annexure 5 in WPC 103.
60. This is more people are there. This is the what is prior to 103. This is the Mara Autonomous District Council Land and Revenue Act 2018. Annexure 5 of
Page?
page 60.
60.
Yes.
60. Yes.
Yes. The Lordship here, the operative portion is 23, that is in page 66. Here, 23.1, the executive committee or concerned authority in its behalf may, the public notification or by official order, levy or collect fixed or control revenue, cess, costs, and charges.
Just a minute.
Yes.
Manghaki, you have anything to type and all that? Yes, 23.1.
Yes. Payable by any landowner or pass holder and may prescribe the manner and period in which such revenue, cess, costs, ban charges are to be paid and collected. Number 2, in exercise of the power vested to it by subsection 1 of this section and subject to the provision of section 22. So first I'll read out section 22, just above 23, Your Lordship. Here, 22. No land survey, spot verification, and measurement over any land allotted to any person by the District Council in accordance with the Mara Autonomous District Council Non-Agricultural Land Settlement Act 2011 and the Mara Autonomous District Council Agricultural Land Settlement Act 2011 or any other law in force in the District Council area shall be carried on by any person, governmental or non-governmental department or agency for any purpose except by the District Council. Number 2, in case any land is necessary for any purpose to be surveyed, verified, or measured, here, Your Lordship, kindly note this, the owner of the land in question shall apply for the same in writing before the concerned authority under the District Council, and the concerned authority shall perform such required work as and when it deems necessary and in the manner as it may deem appropriate. In certain case, the concerned authority may, or its own initiative, perform such needful work under this section as it may find necessary in presence or consultation with the landowner or otherwise. So I'll come to Your Lordship, section 23 2A. I'll come to section 23 2, subsection 2. In exercise of power vested to it by section 1 of this section and subject to the provision of section 22 of this act, the executive committee or concerned authority shall be competent by public notification or by official order to collect revenue from any land pass holder as it may deem fit and reasonable. B, to collect and levy cess to the extent of 15% or cost or charges which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholder from the value of the land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification, survey, and measurement or any other administrative work, or otherwise as provided and envisaged under subsection 1 of section 22 of this act on certain and special occasion as the case may be. C, to collect such fees or costs or charges for mutation from any land or pass holder. D, to exempt certain land pass holder from payment of revenue or other charges on sufficient and reasonable ground. That is, on these 23 bases, they have a issue notification that is in page 68, Annex 6, Your Lordship.
Page?
Page 68, Annex 6.
Yes.
Notification. In exercise of power conferred by Section 23, Subsection 2 of the Mara Autonomous District Council Act 2018, the Executive Committee of the Mara Autonomous District Council is pleased to notify for information of all concerned that the Executive Committee of the said Mara Autonomous District Council shall collect and levy revenue cess to the extent of 10% from any landholder from the value of the land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification, survey, and measurement or any other administrative work, or otherwise as provided and envisaged under subsection 2 of Section 23 of the Mara Autonomous District Council Land Revenue Act 2018 with effect from 19 September 2019, date of notification of MADC Land and Revenue Act 2018. So on this basis, Your Lordship, the respondent has deducted 10% from the awarded amount that is in page kindly see, Your Lordship, Annex 3, page 50. Operative portion is page 55. Your Lordship got it, the serial number 8. Here, administrative cost is taken 2.5% of the total compensation, and the cess is serial number 3. Total cost of land. Cess at the rate of 10% of the total cost of land will be deducted from the individual owner and shall be remitted to MADC directly.
What is this document? Award.
Award, Your Lordship. This is award number 5 of 20.
This is as per the notification of 23/9/2019. Is it?
Yes, that is correct.
Is it mentioned anywhere?
Yes.
Okay, 23/9/18.
Yes.
Okay.
And here, kindly notice that, Your Lordship, serial number 8, they have taken administrative costs at the rate of 2.5% of the total compensation, that it comes to 19,21,144.42 is already deducted here for administrative cost. So I'll come to the Annex 5, Your Lordship. Here it says that the Section 22(2), it says that for measurement and verification and survey, the owner of the land in question shall apply for the measure. So in this case, my point is that, Your Lordship, my contention is that my land is measured and verified or surveyed not from the application from the claimant. This is acquisition process, as you know, Your Lordship. So the acquiring authority asking the respondent for acquisition of the land. So they requested the landowners, and the measurement and all the survey was done by the revenue staff of the MADC at the request of the district collector. So not request from us. So as you know, Your Lordship, in the chart you have seen the award. they have already deducted 2.5% from the awarded amount for the cost of administrative costs. So it's already deducted. In this Revenue Act, it's not says that it's from, so that this 10% or 50% should be deducted from the land acquisition or compensation. It's for the survey and whoever asking for the survey and verification or measurement of their land, they have to request the authority. For that, they have to cess only, not for the compensation. It's clear that. So what I mean to say is that this act is not applicable to the case of the land acquisition. And beside that, Your Lordship, the land acquisition is done in accordance with 2013 LA Act. This is the Central Act. So I'll come to the judgment and order of this Honorable Court, Your Lordship. Kindly come to the Annexure 7, Your Lordship. Page 69.
Yes.
Here, one case is that I'll read from the paragraph 11, Your Lordship, page 74.
Yes.
The issue as to whether 15% cess of the compensation amount awarded to the petitioners could be deducted as cess by invoking Rule 47(4) of the 2013 Act. Well, this 2013 Act is State Act, Your Lordship. Well, the lands of petitioners had been acquired under Railway Act is the moot question in issue. Section 132(1) of the 2013 Act states that the state government may, by notification in the official gazette, make rules for the purpose of carrying out the provision of the 2013 Act. The preamble to the 2013 rules states that the Governor of Mizoram has been pleased to make the 2013 rules in exercise of the power conferred by the Section 132 of the 2013 Act. The above preamble makes it clear that the 2013 rules had been made for the purpose of aiding and carrying out the provision of the 2013 Act. Rule 47(4) of the 2013 rule states as follows. In case of acquisition of land covered by house pass or stall pass or soap pass or periodic pata or land lease under Land Acquisition Act, as amended from time to time, compensation may be paid as per assessment made by the concerned collector of the district, provided that the validity of the tenure of the said land holding has not expired. In addition to crops and building damage compensation, land value may also be assessed, and out of the assessed amount, 15% of land value shall be remitted to Revenue Department as cess on value of the land. Your Lordship, kindly notice that here it's land lease under the Land Acquisition Act. They have mentioned. And para 13. However, Rule 47...
Ms. Dinari,
Yes.
you please come to page 75,
Yes.
paragraph 12.
Yes.
There's an abstract of Rule 47(4).
Of the
Mizoram Act,
Revenue
2013 Act.
Yes.
It begins by the statement, it
Yes.
begins with a sentence.
Yeah.
In case of acquisition.
Right. It's different.
It is different.
Different.
In
But
MITC, it's not like that.
yeah, yes. I'll come to my point that, Your Lordship, it's not that. Even in acquisition of land, they have cess 10% in the state government. This itself also set aside, this Honorable Court said that it's not applicable. So I'll come to the main
No,
point.
why the court said it's not applicable was because of the fact that the acquisition, if it's done under any law which is not of the state government, then you
Yes.
cannot apply.
Yes.
If it's under the law made by the state government, you'll have to pay cess.
Yes, yes. In that point, I'll come to that. Even in the case of the present instant case, Your Lordship, this acquisition of land is in accordance with 2013 LA Act. That is Central Act, not MADC Act or State Act. That is, I mean to say that.
I understand.
Yes.
But
And
it does not, the provisions are not similar.
not similar.
In
but
MADC, it
the
doesn't say
ratio,
that. It does not say that if there is an acquisition under the MADC law, we'll
Yeah.
deduct cess.
Yes.
If it is under the any other law except for MADC, there'll be no deduction.
Yes.
It doesn't say that.
Yes, it doesn't say that. But in the ratio here, Lordship, kindly see para 14, it will be more clear here.
No, how the ratio is going to be applied?
Yes.
I fail to understand.
What I mean to say is that here this Honorable Court says that 14, in the present case, the petitioner's lands had been acquired under a Railway Act 1989, which has been enacted by the Parliament. Also, the government of Mizoram Land Revenue Settlement Department issued a notification such and such, which provides that during the period, Mizoram Acquisition, Rehabilitation, Resettlement Act 2016 is sub judice. Lands for the National Highway Project and Railway Project in Mizoram shall be acquired under the relevant provision of the National Highway Act 1956 and the Railway Act 1989 respectively. Here, Your Lordship, kindly note, in view of the above, it is clear that as acquisition of the petitioner lands have been made under a Central Act. So in the case of the present case, Your Lordship, the acquisition is made under the Central Act, that is 2013 LA Act. Accordingly, the respondent number 1 to 3 could not have invoked the provision of Rule 47(4) of the 2013 Act for deducting 15% cess from the compensation amount awarded to the petitioners in terms of award number such and such. Consequently, the deduction of 15% cess by the respondent number 1 to 3 is illegal and not sustainable in law. The respondent number 1 to 3 are accordingly directed to immediately release the deducted 15% cess to the petitioners. The same should be done within a period of 1 month from the date of receipt of a copy of this order by depositing the said amount in the office of the concerned Deputy Commissioner, District Collector, who shall thereafter disburse the amount to the petitioners. So, Your Lordship, as you have seen the Revenue Act made by MADC, it's not mentioned that land acquisition. It's only mentioned that survey, verification, measurement.
See, on that point, it's okay.
Yes,
You're saying that administrative cost and all those things are there.
yes,
It's not meant for acquisition. Okay.
right, yes,
That is one point.
yes,
But the point which you're trying to make by comparing with this case,
yes.
I don't,
Yes.
I don't see that, where is the scope of there being comparison? Because this 2013 State Act
Yes,
initially said that any acquisition made under the LA Act of 1894,
oh, yes,
cess will be deducted.
yes,
That was amended subsequently by saying that instead of Land Acquisition Act, amendment say that any land acquisition or law or policy of the government of Mizoram. So it was because of that the court had held that
yes,
acquisition was made under the Highways Act,
Yes.
it was made under the perhaps the 2013 Act. You cannot deduct
yes,
because the amendment itself provides that it has to be an acquisition under the laws of Mizoram.
yes,
But when the acquisition was done under the Central Act, you cannot.
yes.
So
So
in respect of MADC,
yes,
what you can say is that as per the provision given here,
yes,
there is no question of deducting cess,
Yes,
because whatever is provided here is for on application by the landowner
yes,
for making verification, for making survey.
right,
If that is a thing, they will, okay, you can pay cess.
Yes.
But if you have not made application, why should you pay cess?
yes.
This is what you want to say.
Yeah, yes, that is my one point. Second point, what I refer, the one I have referred, the judgment of this honorable court is that if the land acquisition is processed or in accordance with the Central Act, why should whatever Revenue Act, even if the assess is deducted from the Land Acquisition Act, land acquisition, this cannot be made because the acquisition is made in accordance with 2013 LA Act, that is Central Act. So they cannot applicable beside this one point you have mentioned. So this ratio can be applied to the present case also. This is my point, Your Lordship.
So if the MIDC has got its own acquisition act,
Yes.
and if acquisition is made under that act, they can deduct.
Yes, if they can make land acquisition, this is the ratio here, it's mentioned here. In
But they
the
don't have any acquisition
Yeah,
act.
that's why they cannot make a cess.
No, you're trying to draw a comparison with the state act.
Yes,
State act has got its own laws.
yes,
2013 act was said to be not, 2016 act,
yes, yes.
Mizoram
Yes,
Act,
yes.
2016 act,
Yes,
is said to be not applicable.
not applicable.
But that is under challenge now. There
Yes,
is no outcome.
It's the outcome is here now. Your Lordship, it's dismissed. I've heard that my learned-
Dismissed?
Dismissed, yes, today.
Okay.
So
So what will apply now? 2013 act.
13
Okay.
Act is applied now. That is why.
So anyway,
Yeah.
the state had the 2016 act,
Yes. If they have their state.
and because of that reason, this provision was there.
Yes, yes.
Amendment was made,
Yes, that is
replacing the LA Act.
correct. Right.
Because LA Act has been replaced by the 2013 Act.
Right.
And since the state said that we don't want 2013 Act, we'll have our own 2016 Act, I
That is
think.
correct. Yes.
But then that 2016 Act was made to be not applicable.
Yeah, at this stage, yeah.
Before that, they made an amendment here.
Yeah.
Since we already have our own act,
Yes.
we'll make this amendment saying that we'll just omit
Yeah.
LA Act 1894 and insert the Mizoram Government of Mizoram Act.
Right. Right.
So
the
that
case
is
of
why
the
the
pres-
court held that since acquisition was not made under the Mizoram Act,
Yes.
but by the Central Act,
Yes. In that
you
point-
cannot deduct cess.
Right. This point, it's a ratio
On
can
that
be
point,
applied.
it's clear.
Yes.
But insofar as your case in MADC is concerned,
Yes. They have no Land Acquisition Act at all.
there is no Land Acquisition Act.
Yes. That's right.
The only cess, the way they have
Is
reason
the-
why they have deducted cess is because of this provision of 23,
Yes.
section 23(1).
Right, right. That is, I mean to say that, Your Lordship.
So,
So it's only made, the assessment as well as land acquisition is made under Central Act, that is 2013. So even the state law or as well as MIDC law cannot be applicable in that. That is the ratio I want to make it. And beside that, as you know, Your Lordship, even in the award, it's already deducted 2.5% for the administrative cost. It comes 19 lakhs. And if the cess 35 lakhs cess is deducted again, so altogether it will come to almost 50 lakhs from the compensation received by the landowners.
so your main point perhaps is that they can fix revenue cess, costs,
Yes.
charges, etc. but that can be fixed or that can be applied when there's a question of conducting spot verification, survey, measurement, or any other administrative work.
On the request of the landowner.
That charge will be there.
Yeah, that charge will
But
be
when
there.
it comes to acquisition,
Yeah, this cannot be applicable.
why should they deduct cess?
Yes.
This is what you're questioning.
That is there, Lordship. That is my point. And Lordship, now we'll come to the,
But it is a good way of making money, isn't it?
right, that is correct.
Be done by the MADC only.
MADC only.
So,
So that is done
when
by,
acquisition is done,
yes,
collector has a role to play.
a role to play on the request.
And when he has a role to play,
Yes.
he cannot do it because the act prohibits. So he requests the revenue
request-
authorities,
Yeah, that is correct, yes,
and the revenue authorities have done the survey, demarcation, all that,
yes.
and for which, according to you, administrative charge is already deducted.
0.5% is
Already deducted. And beyond that, we are not liable to pay anything.
Yeah, that is my point, Your Lordship. And number two, my points, they have 33 of the Act, interest is calculated from the date of issuance of notification, that is 13/8/2018, to the date of the award.
Is this under section 33? What is subsection 3?
They mix up here, even though they have made this award in accordance with 2013. They have, I don't know what is
No,
the
this is solatium.
solution.
Do you have the LA Act 2013?
Yes, I have.
So just check up section 30.
Section
This is
30.
award of solatium.
Yes. This is award of solution only. Okay.
The collector, having determined the total compensation to be paid, shall arrive at the
Award,
final award.
right.
Impose solatium
31. Yeah, solution
equivalent
only.
to 100% of
Yeah.
the compensation amount.
And 6, next, interest 12% of under 33. Also, they have deducted. In addition to the market value of the land provided under section 26, the collector shall, in every case, awarded an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of the publication of notification of the social impact. So it's not at all.
No, Ms. Dinari.
Yes.
This seems to be in order. Serial number 5 and 6
Yes, yes.
appears
same
to
order.
be in
Yeah,
order.
In order. In order.
Now, what you're claiming is, in addition to this interest,
Yes.
you should be given interest under section 80.
80. That is 80. Yeah.
What does 80 say?
80 says that.
80 says that if possession is taken without payment,
Yes.
then you should be paid interest.
Yes. Yeah.
So that is
prefer-
different.
Yeah. That is different. I mix up. I'm sorry, Lordship. It's only the payment of interest in accordance with section 80 of 2013 Act. It's not paid at all.
Okay.
So this may be.
So
with this
when according to you was possession taken?
Lordship, even though here they have mentioned that the construction is started in the year 2007, but in my version, my our land is took place in September 2010. Possession was taken.
September 2010.
Yes. This is the statement of my client. I have mentioned here.
Where?
Para 2 of my
What is the
state-
response?
Nothing.
So who
No
will decide
dispute.
that?
It should be decided by district collector, state respondent.
Construction of road took place
Since 2007.
September 2000.
Uh,
No, since 2007.
and that the said constructors of road over the land of petitioners took place during September 2010.
So 2007 there was no disturbances.
Yeah, in my there's the long road from Lakipura, and when it comes to my land, from the statement of my client that possession was taken in the year 2010 September. There is no dispute in this regard by the respondent. No dispute. And the state government said that if this honorable court directed will calculate it, the interest. They have said that. Even the CGC is not dispute with regard to the. And I'll come to the judgment.
She's smiling away.
Yeah. Lordship, I have read out their affidavit and there's no dispute at all. I'll come to the judgment of this honorable court, Your Lordship, with regard to this. Kindly see page 78, annex.
You are submitting for CGC also.
Yeah, I have read. Because there's no dispute at all.
Okay. 78.
Yes. Got it, annex 7.
Yes, what is this?
Judgment of with regard to the interest. Kindly, I'll read from Your Lordship.
Now, interest under 34.
Yeah, this is 1894.
I understand.
Yes.
See,
Here-
just hear me out.
Yes.
Interest under section 34 of the LA Act
Yes.
is similar to interest under section
Yes.
80.
Yes.
Okay, then you need not go into this.
Yes. In this case,
See,
Your Lordship-
we cannot say that you calculate interest from this date.
yeah, you cannot. say
All that we can say, perhaps, at the end of the day,
Yes.
you examine whether possession was taken before payment.
Yes.
If possession was taken before payment, then you have to apply section 80.
Right.
So
Right.
collector will find out.
Yes, the
Or
direction of
he'll
this-
be on the ground.
Uh,
From here, we cannot say which date is the correct date.
I understand that, Your Lordship. This honorable court also, here the direction is made like this. In the result, the writ petition is disposed of with a direction to the district collector, Siha district, to calculate the interest payable to the petitioners in terms of such and such. Para 7, Your Lordship.
Yes.
Yes, the same thing, Your Lordship.
That is your
Yeah.
second claim.
Yeah, second
Now,
claim.
third
And the
prayer. What is the third prayer?
Third prayer, the reference court has to be made, and the respondent authority,
In terms of?
in terms of section 50, #51 and 52 of LA Act 2013. Lordship, got it?
51.
51. I'll read from 51. Is it more clearer? The appropriate government shall, for the purpose of providing speedy disposal of dispute relating to land acquisition, compensation, rehabilitation, and resettlement, establish by notification one or more authorities to be known as the Land Acquisition, Rehabilitation, and Resettlement Authority to exercise jurisdiction, power, and authorities conferred on it by or under this Act. 2. The appropriate government shall also specify in the notification referred to in subsection 1 the areas within which the authority may exercise jurisdiction for entertaining and deciding the reference made to it under section 64 or application made by the applicant under the second proviso to subsection 1 of section 64. 52. Composition of authority. The authority shall consist of one person only. Herein after referred to as the presiding officer, to be appointed by notification by the appropriate government. So in this regard, the state respondent says that the stand of the state respondent is that if the 2016 LA Act is subsidized, we cannot appoint. However, this honorable court directed us to appoint, will do the same. This is the admission.
What
if
thing?
If this honorable court directed to appoint the authority, will definitely comply with the statement of the state government.
Where is that?
Affidavit.
In the affidavit?
Yes. Yeah, I'll come to the affidavit of the state government.
In WPC 60 only.
60.
The state is respondent number 3 and 4.
3 and 4, Your Lordship.
Yes, paragraph 13.
13. That with regard to statement made in paragraph such and such, I say that since MLARR Act 2016 is subsidized before division bench, Guwahati High Court, the government of Mizoram could not establish the Land Acquisition, Rehabilitation and Resettlement Authority. If the Honorable High Court desires to constitute the said authority, the government of Mizoram is ready to constitute at any time. And with regard to the cess, Your Lordship, here, para 11 of affidavit, that with regard to the statement made in paragraph number 12 and 13 of the writ, I say that if this Honorable Court finds it fit to make such calculation as per section 80 of such and such, the same will be done promptly.
It is not the court who finds it fit. It is the act which says.
Yeah, the act itself says, yeah.
Act is made by the legislators.
Right.
It's not the court who's making these acts.
Yes. Your Lordship.
Whether you find it fit or not, that is not the question.
And
the act provides for it.
Yeah. In the second case, in their affidavit, the deducted cess is lying before the district collector, Siha. They have mentioned that. It's not released to the MIDC yet.
Where?
In the second
case.
Yeah, affidavit by the state.
Let us see. State is 3 and 4 again.
Yeah. Kindly see page 4, para 7. That with regard to the statement made in paragraph number 7 of the writ petition, I say that the 10% revenue cess deducted from the land value compensation of landowner is still lying at the office of Deputy Commissioner Siha as instructed by the government by such and such. So the government says that not to release to them because in some cases in the Annex 4.
Annex 4 is the document.
Yes, document.
Then what about the judgment of the writ appellate court in that case?
Yeah, we heard that
Who has it?
It's dismissed. You have not read. My learned friend.
Today.
Today, yes. Mr. Nair is counsel. The Nair informed my learned friend. Yes.
What bearing will it have to this case?
Nothing.
There's no
because this case is directed by this Honorable Court to acquire the land in accordance with 2013 LA Act. So, in accordance
Where
with
is the direction?
Your Lordship, in the judgment.
This is a second round or what? This is a second round writ petition?
No. This is a first round. However, for acquisition, to acquire my land, I have approached 3 times.
Where is that?
Here in the judgment itself says that.
Where? Which page?
Yeah, I'll come to that. Your Lordship, kindly see page 37.
Of which writ petition? 103 or 60?
60.
60. Page 37.
37. Operative
Same petitioners.
Yeah, same petitioner, 45. This operative portion, page 45. Second paragraph.
Operative is page 45.
45, second paragraph.
Okay.
The petition case in brief is that BRT had constructed a road through the lands of petitioner as no compensation was paid to them for acquisition of the same petitioner filed WBC 2 times. This 53 is the third one. So it's, and here it's a direction, is the operative portion is that, Your Lordship. It's in page 48, kindly see page 48. And the direction of this honorable court is from 48, Your Lordship.
Okay, before this you had come by way of WPC 160
Yes.
and 224.
224, and this is the one I've read out is
53.
53.
What was the direction in 160 and 224?
Here, spot verification of petitioners, and they have made the spot verification, but they have no notify in accordance with law. It's only on notifier 0 to 20, and we are in 20 to 30.
Okay, in those
So,
those two cases,
Yes,
160 and 224,
Yeah.
notified till 0 to 20
yes,
in both these cases.
yes.
And the petitioners in 53 are beyond 20.
Beyond 20, that's why direction was made
Okay.
here. Your Lordship, here I'll read out from page 48, para 10. Your Lordship, the short one. Lordship,
It's
got
okay,
it?
I've read it,
Yeah.
Mr. Dina,
Para
I've read
10,
it. You
yeah.
need not.
Here it's provide for following the provision of right to fair compensation and transparency in land acquisition, rehabilitation, settlement act 2013.
So ultimately, acquisition was done under
Done,
2013
yeah,
Act.
yes.
And now you're back again because you say that cess has been deducted
Yeah.
and section 80 interest has not been given.
And
And
for
thirdly,
market value of the land, you have dispute, you have no court to approach.
okay.
Authority to approach.
Now, as per this section,
Yes,
like in the old Act of
yeah, yes.
94,
94 also there.
no, there was a reference.
Yeah.
What I meant,
Yes,
what I wanted to say was, there was a time limit for filing reference.
right,
6 weeks from the
Right,
date of
right,
knowledge
that is
or 6 months like that.
yeah.
Now, what does it say in this new Act of 2013? Is there any time limit?
Time limit.
The authority,
Yes,
how do you go for reference in this Act?
here 64, if you read out 64, Your Lordship, reference to authority, any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for determination of the authority, as the case may be, whether his objection be to the measurement of the land, the amount of compensation, the person to whom it is payable, the rights of rehabilitation, resettlement under chapter such and such, provided that the collector shall, within a period of 30 days after collector receipt of the same, from the date of receipt of application, make a reference to the appropriate authority. Provided further that where the collector fails to make such reference within the period so specified, the applicant may apply to the authority, as the case may be, requesting it to direct the collector to make the reference to it within a period of 30 days. So my understanding is that, yes,
From what you read, if you go beyond that,
yes,
the same provision is there.
yes.
64 subsection 2 A and B.
The applicant shall state the ground.
Same as the reference under 18.
Yes, under it. 6 months from the date of collector's award.
It's initially 6 weeks from the date of collector's award.
Right, B.
In other cases, within 6 weeks
Yes,
from receipt of notice
yes.
or within 6 months from the date of a collector's award.
So in the case of
This is the same thing in 1894 also.
yeah, same thing. Same
Now,
thing.
what will happen in this case?
In this case, there is no authority. You have approached collector, and the collector says that you have no such reference code. So it's you cannot process. Here I have mentioned that even I have submitted before the collector, and RTI also there. Your Lordship, yes, I'll come to that. Kindly see Annexation 9. This is my application under Section 64 of Right to Fair Compensation. Annexation 9.
Page?
Page 82.
Where's the reply?
The reply is it's pending like that for so long. So I have approached RTI, and RTI the reply is Annexure 10, that is page 94. Translation is 95. So since the
That's all, the reply? No further reply?
no further reply.
Then you file this writ petition in 23.
Yes.
So that is your case.
Yeah, that is.
What is the difference between these two writ petition?
It's the same thing. Even in this case, they have when they make a word, they have excluded these 7 petitioners, and they have a new award made for them, additional award.
Who were excluded?
This Johnson and 6 others, the read petition 103.
They were excluded from the award number 5 of 2020.
Right, right.
So now fresh award was made.
Yes, additional award is made
Page?
for them. Page 40, Lordship. Second
40.
40.
40.
40.
Then this is additional award.
Additional.
Then
Award number 5 of 5 additional 1 of 2020.
again same thing. Cess was deducted.
Yeah, everything is same.
Cess was deducted.
Deducted.
And
Interest
you have not been
paid.
given that section 80 interest.
Yes.
And
even asking
the
for the
reference also was not there.
Yeah, same thing. Only the award is different. Award number is different.
Award number 5 of 2021.
Yeah.
But it's additional award.
Additional 1 of 2021.
Okay.
Everything.
Additional award number 1.
1 of 2021. Award number 5 additional 1 of 2021.
So how many additionals are there? If they put additional 1, that means there may be 2, 3, 4.
Maybe in other case.
Okay, not in your case.
Not in my case. And I've gone to the state government affidavit as well as CGC. CGC does not dispute my prayer for the sales as well as the calculation. And they only said that they have paid this
Because
much.
she says that we have given the money.
Yeah, that's all. Nothing.
Whoever
dispute.
takes it, it is not our business.
Yes, yes, that is there's no dispute regarding the calculation of interest, all these things. That is my prayer, Your Lordship, 3 prayers.
Okay. Let me hear the other side. Mrs. Dinari has submitted for you. Anything left?
In this case, my lord, the petitioner prayed 3 portion of prayer, my lord.
Yes.
Regarding the cess, I have nothing to say.
Okay.
In between the petitioner and the
MIDC.
MIDC and state government, my lord.
Okay.
However, regarding B, that is in terms of Section 80 of Act 2013, payment of interest, my lord. The petitioner did not enclose any certificate of taking possession of the land. In the meantime, in their writ petition at para 9, my lord, they admitted that they cannot ascertain the date of taking possession of the land. Then, if I may permit it, para 9 of the writ petition.
Which one? 60 or 103?
60, my lord.
Okay. Paragraph number
9.
of the writ petition.
Yes, my lord. 10. Page number 24.
24.
Yes.
Yes.
If I may permit it to read, my
Yes.
lord. The petitioner would like to further state that the respondent authority under the MBDC had already begun construction of the road on 2007, and the said road was constructed over the land of the petitioner sometime during September 2010. In other words, the respondent authority had taken possession of the petitioner land back on September 2010. However, it was only avoid the notification issued under Section 4, Clause 1 of the Land Acquisition Act 1894 on 14/3/2013, which was published in the Mizoram Gazette on 15/3/2013, in respect of a stretch of land from Kolso Pura Tongkolong 0 to 20 kilometers that the petitioner land were affected can be traced back officially. At this stage, irrespective of the fact that the land of the petitioner were situated between 0 to 30 kilometers, that the facts that the respondent authority had already taken possession of the land of the petitioner can be appreciated from the award number 5 of 2020, where it was stated at para 5 of the para 1 that it found from the record that assessment on property damage was already done on 24/2/2010, and compensation was already given to the other similar situated landowner by letter dated so and so, and thereby utilization certificate was issued by the concerned senior revenue officer or MADC. However, due to absence of the concrete evidence regarding the date of taking possession of the petitioner land during the year 2010, it is pertinent to mention herein that the date of issue of notification dated 14/3/2013 issued under Section 4, Clause 1 of the Land Acquisition Act 1894 can be indisputable taken as the date of taking of possession of the petitioner land. My lord, the petitioner themselves also admitted that they cannot ascertain the date of possession of the land. In the meantime, my lord, no certificate for taking possession of the land has been enclosed by the petitioner. In the meantime, the award number 5, kindly see my affidavit, my lord. Award number 5 of 2020. And that was at page 22. Affidavit filed on 30/4/2024, filed by respondent number 1 and 2.
Page?
Page 22.
Respondent 1 and 2.
Yes, my lord.
Page 32.
Yes, my lord. 22.
22.
Yes.
Yes, award 5 of 20.
Yes, award number 5 of 2020 was issued, my lord. The date of issuance has been recorded at page 27.
Yes, what is this? 31.
31/1/2022. That is the date of issuance of this award number 5.
No, 2020. Not 22.
Oh, 20, I mean 20, my lord.
Yes.
In the meantime, in my affidavit, at para, in my affidavit, at page 31, payment of that award number 5 of 2020 has been made on the same year, August. There is no delay payment from the date of award. However, my lord, regarding the taking possession of the land, that is a disputed question of facts.
That is why.
Yeah.
That is why what I said earlier.
Yes,
The collector will look into it.
yes.
Let him examine. He will hear the parties. Not that he will decide unilaterally, this is the date, you must accept it. He will hear the parties and decide which date was the date.
But
Now,
however,
regarding-
my lord, the disputed of question of facts should be decided before civil court only, my lord, by taking evidence on oath. It may be better.
Yes, if the need arises, definitely they'll go there.
Yeah.
And now, for example, what about the reference court or the authority? If that is appointed, can he not look into that aspect also? He'll be a civil court, he'll have the powers of a civil court. The 1894 Act says the principal civil judge.
Yes.
Normally, the reference court is a court of a district judge or a additional district judge. They have the powers of a civil court. Okay. Number one, you have one prayer, first prayer, you have nothing to say.
Yes, my lord.
Second prayer, you say that they themselves have disputed. They
Yes.
themselves are not sure about the date.
Yes, my lord.
Then regarding the appointment of the authority, what do you say?
But regarding that is different issue, my lord. As per my humble understanding, that's even I am not aware of who will be liable for not establishing that authority, my lord. That any order in this regard, as your lordship deem fit and
Okay.
proper.
That's it?
Much of that.
Yes, Mr. Fagoma.
My lord, regarding the
comment.
redetermination of the market value of the land, I am supporting the affidavit filed by the state respondent.
Which is?
Regarding
I have not pressed because if this honorable court directed to appoint the authority, it's not required. Here I have two prayers, market value of the land, and this honorable court can exercise extraordinary power if not appoint authority. That is there. If the authority is appointed by this honorable court, the market value can be disputed before the reference court.
Correct. The court doesn't have the expertise to increase the market value. How will this court increase the market value without examine the evidences to be led by the parties? Under 226, it may not be possible.
Yes, my lord.
This is the job of the reference court. Yes.
That
Government.
much, my lord. Obliged.
Your Lordship, my oral submissions are limited to two things, which is that with regards to the formulation of the Land Acquisition and Resettlement Authority, there was no pleading nor prayer in the writ petition as such. It was only mentioned that such an authority does not exist. So, therefore, Your Lordship, the petitioners may not go beyond their pleadings, and that is why, Your Lordship, that is my first submission, and the other is regarding to the reference application. It is time barred since it was only filed a year later, Your Lordship. And again, Your Lordship, we determined for the determination of market value of land, that as already submitted in para number 6 of WPC 60 of 2023, page number 4, Your Lordship.
Yes.
May I read, Your Lordship? The criteria for determination of market value of land both in RFC TLA Act 2013 and the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016 is similar, which should be based on sale records of sale deeds registered in Registrar of Land Revenue Office. The market value of land could not be determined on the basis of sale records, sale deeds, as there is no reliable sale deeds and sale proof to be fixed to be based for fixing land value.
See, from where are you reading that?
Your Lordship, WPC 60/2023.
In the writ petition or counter affidavit?
My affidavit, Your Lordship.
Oh, your affidavit. I'm looking at the writ petition. Just a minute.
Respondent number 3 and 4.
Respondent numbers 2 and 3, is it?
3 and 4, Your Lordship.
3 and 4.
It is filed on 11th September 2023, Your Lordship.
It was just here. Just a minute. This page is somewhere. Yes, paragraph number?
Page number 4, paragraph number 2, Your Lordship.
Yes.
The criteria for determination of the market value of land both in RFC TLA Act 2013 and the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016 is similar, which should be based on sale record of sale deeds registered in Registrar of Land Revenue Office. The market value of land cannot be determined on the basis of sale record, sale deeds, as there is no reliable sale deeds and sale proof to be based for fixing land value in records of Land Revenue and Settlement Department, Mara Autonomous District Council. Therefore, market value of the land was determined in line with the compensation already paid via award number 3 of 2013 along the same stretch of road, that is 00 to 20 kilometers of Katau Pura Tukalo Road, which was presumed to be appropriate. Further, there is no reliable record on which there is a particular rate of annual increase in market of the land in question. So, Your Lordship, those are my submissions.
Okay.
Please, Your Lordship.
Yes.
I'm for the respondent number 5 and 6, MADC. So again, like my learned friends, my submission would be limited to the first prayer of the petitioners. That is regarding that deduction of cess.
Cess.
Right.
MADC is respondent number?
5 and 6.
5 and 6. Yes, what do you say about that cess?
Yes. At the outset, Your Lordship, what I would like to mention is that no challenge has been made in the present writ petition, or as far as my knowledge goes, before any other court challenging regarding against the notification dated 23/9/2019, by virtue of which the cess were deducted. Now, cess, Your Lordship, as per my understanding of a cess, what is a cess? Is that it is a tax that is imposed by a government for a particular purpose, be it for education or for some social infrastructure. So that is a form of a tax which is taken by the state. Now, the lands in question, the lands of the petitioners, they were all issued under the MADC Land Revenue Act of 2018, which is an act promulgated, formulated, and notified in the official gazette under para 11 of the 6th schedule of the Constitution of India. Now, as far as the deduction of cess is concerned, I think my understanding of this particular provision, that is particularly section 23, subsection 23(2)(b), my understanding is that a cess may be deducted for conducting spot verification, survey, and measurement. It has nothing to do with land acquisition per se. It has nothing to do with State Acquisition Act, Central Acquisition Act, or this act or that act. We are allowed by our act to deduct cess for these three things: spot verification, excuse me, survey, and measurement of or any other administrative work. Now, out here, my learned friend has submitted that since, as per section 22, since section 23 is subject to section 22, and in section 22, my learned friend had read out that there was no application made by the landowners for conducting survey of their lands. As such, section 23 could not have been applied. Regarding that, one cannot lose sight of the fact that the entire ball got rolling because of the actions of the petitioners. It was due to their writ petition that all these acquisition proceedings happened. So in a way, they have in fact indirectly said that, please, this is my land, look at my land, please conduct a survey of my land to verify whether this BRTF has constructed road or not. That was their prayer, to conduct spot verification. So it was at their behest that these spot verification were carried out. In any event, I would like to take your lordship's attention to section 22, subsection 2. I am relying on the writ petition, page 66.
Yes.
I'll just read. In case any land is necessary for any purpose to be surveyed, verified or measured, etc., the owner of the land in question shall apply for the same in writing before the concerned authority under the district council, and the concerned authority shall perform such required work as and when it deems necessary and in the manners as it may deem appropriate. Now, I would like to stress on the next paragraphs. In certain cases, the concerned authority may, on its own initiative, perform such needful work under this section as it may find necessary in presence or consultation with the landowners or otherwise. So, by virtue of this last paragraph, application from the landowners is not compulsory. In certain cases, their presence or consultation is also not necessary. Now, my action of conducting spot verification and survey of the lands of the petitioners was due to the directions of this honorable court. As a result, in my humble opinion, consultation or even the presence of the landowners or their application, lack of application, so to say, is no longer needed.
Yes.
That is my first point. And secondly, Your Lordship, my learned friend has stated at page 55. Page 55 of the writ petition. Here, my learned friend had pointed out that 10% says that serial number 3 has been deducted, an amount of so and so, and administrative cost at serial number 8 has been deducted, an amount of so and so. What I would like to stress on is these are two very, very separate things. Cess has been deducted by virtue of section 23 of the Mara Autonomous District Council Land Revenue Act of 2018. Administrative cost of 2.5 is deducted as a result of a direction or a notification of the although I don't have a copy, but my knowledge is that the Ministry of Surface Road Transport had put a cap on all state governments, saying that if you're taking any administrative cost for land acquisition, we will cap it at 2.5, because some state governments were taking 13%, 10%, so on and so forth. So in 2015, they had issued a guideline to all the states saying that if you are taking any administrative cost, it is capped at 2.5. So these two deductions are under two separate heads and they are not the same.
So this administrative cost would go to whom?
Will go to the, in my humble opinion, it will go to the state government. So I am not sure on that. In any event, it is not the case of the petitioners that administrative cost is already deducted, so you cannot deduct cess. That is not in their pleadings. That is not in their prayer also. That is not their case. Nothing is mentioned about administrative cost in their petition. And also, now, Your Lordship, I would like to take Your Lordship's attention to my affidavit. Page 31. This is in the Mara language and the English translation is at page 32. So, cess could be deducted for conducting survey, measurement and spot verification. This is a detailment report for conducting spot verification, and those are the persons. This B. Johnson is in fact is the first petitioner in the other writ petition. And next at page 34, This is a survey report. Page 35. Again, at page 35, for example, that name is there. I might pronounce the name incorrectly, but such as Thonala / Pass. This is petitioner number 37. At the bottom, HCBSO. This is petitioner number 2. That B. Johnson's name is also there. At the next page, Your Lordship, that at the top right corner, at page 36, the name of the petitioner number 1, Zhou Shuailian, is also there. So it is not a case that we just simply deducted cess.
No, what is this? Otherwise?
These are a verification report.
Verification report.
Verification report. So I had asked for the verification report to show, to prove to this honorable court that all these exercises were undertaken, in fact. So, again, what I would like to stress on is that the deduction of cess has nothing to do with land being acquired under state or central act. It has only to do with the conducting of spot verification and measurement and survey, which was done in this particular case, for which we have annexed this annexation, page 34 of my affidavit. And also owing to the fact that this notification for deducting cess has never been challenged, even in the instant case. No illegality has been done by the MADC. And in fact, perusal of the entire writ petition would go on to show that the petitioners have not pointed out a single violation of any provision of law by the MADC in deduction of cess. Although they have relied on certain judgments of this honorable court, which in my humble opinion, and in which your lordship had also rightly pointed out, would not be applicable in the instant case. Apart from that, there is no allegation made by the petitioners that the MADC, by deducting cess, has violated section number this or that of the act. Nothing is mentioned. So in my humble prayer as such is that since there is no violation or illegality performed by the MADC, so far as the deduction of cess is concerned, where is the maintainability of this writ petition so far as prayer number 1 is concerned? What legal rights of theirs, what fundamental rights of theirs have been violated? They have not mentioned that.
There must be some criteria otherwise.
For my lordship?
For this cess. Now you say that, okay, the cess is there towards the verification, survey and all that.
Right.
So, I mean, what is the math? How do you work it out? We just have a round figure.
No, as per section 23, I apologize. As per section 23, subsection 2B, we can, in fact, we are authorized to impose cess up to 15%. But as per the notification, we have decided not to impose the maximum, but rather we fixed it, we capped it at 10%.
10% of?
The land value.
And how do you determine land value?
Valuation certificates are there, Your Lordship. Land valuation certificates are always given.
Do we have any specimen?
No, Your Lordship, we don't have. I apologize. If Your Lordship could kindly rephrase, I did not get that question.
No, land valuations made prepared actually basically for making tax, paying tax and all that.
No.
Like in the state, we have the LSC.
Correct.
Land valuation certificate, non-incumbent certificate and all that. And the valuations are not very high actually.
Most probably. The government valuation, the value of land as per the government
actual
rate.
Market value which it fetches and the land valuation given by the revenue department are not similar.
Yes, but unfortunately that is not the case of the petitioner. So in any event, Your Lordship, the valuation of the land value was already determined by the DC when it passed its award number 5 of 2020. And even the petitioners have accepted that although under protest, the valuation of their land, they've already, if My learned friend may correct me if I'm wrong, but I believe that they've already been paid their compensation less this cess amount. So again, Your Lordship, perusal of the writ petition does not disclose any specific pleadings to say that this right or this law or that law has been violated. It basically says that as this honorable court in so case has done it, the same should apply. The cases relied upon by the petitioners relates to the Mizoram Land and Revenue Act of 2013 and its rules of 2013. Out here, the land holding is governed by MADC Land Revenue Act 2018. That would have no bearing on this. And if I'm not mistaken, Your Lordship, in that particular rule, which was subsequently amended, it says that any land acquisition so which is a policy of the state government. And I believe, as per my understanding of those judgment, was that this honorable court's judgment was to the effect that since those acquisitions were done by the central government and not the state government, that's why you cannot deduct cess. I believe that was the import of this honorable court in those judgments. In any event, Your Lordship, again, my last submission, and with this I would conclude, is that deduction of cess has nothing to do with land acquisition, be it central or state. It is only for those spot verification, survey and measurement which were actually done on the ground that we have deducted cess. And considering the fact that the Land Revenue Act of MADC has been promulgated under paragraph 11 of the 6th schedule, and since there is no challenge to the notification dated 23/9/2019, we are allowed to deduct the cess. My learned friend may say that is right or that is wrong, but they have to put this notification to challenge to say that.
Okay, that cess amount is on hold as of now?
As per the affidavit of the state, yes. But I believe that this is in relation to some other case, Your Lordship. Because if we look at the award of the petitioners...
you are the MADC, so you should know whether the cess amount has been released to you or not.
My understanding is that it's been released, but I cannot... I'm B. Johnson. State. Johnson.
Anything that you mentioned in your affidavit regarding the release or not, otherwise?
No, Your Lordship, because that question was never placed before me.
The state otherwise thought it convenient that it should not be released because there were some various claims have been made for release, for refund. Where is that statement which you pointed out, Mr. Dinari? Regarding cess not being released?
Yes. WPC number 103, affidavit by the state
Oh,
government.
in 103.
103. Affidavit by the state respondent, paragraph number 7.
This is different, Your Lordship. Page 21, Annexure 4 of the affidavit of the state in B. Johnson.
This is generally to everyone.
Yes. Yes.
Aizol, Lunglei, Siaha,
No, but
Champhai.
Your Lordship, you will find that this is railway line project.
Railway line project.
Yes.
Where?
So the present case is construction of road by the BRTF.
So, slightly different.
My lord.
But then the second paragraph, just see. In the present circumstance, there will be a lot of petitions for release of cess amounting, especially with regard to national highway project, in which the court tends to dispose of them in favor of the petitioner. Anyway, doesn't make a difference whether it was disbursed.
Because the appeal case that is being referred here has been finally disposed today, so it's in light. I believe it's in light of that writ appeal regarding that.
What is that writ appeal number?
You know, I don't have it ready with me, Your Lordship, but I can find out. I'll find
Writ
out.
appeal disposed of by Division Bench 1?
That information is because I received only one small message saying that appeal dismissed from my colleague.
Okay.
And
Must
also,
be
it's
probably
not-
DB1. We have DB1, DB2 and all that in principle. See, that's
Most probably, my lord.
none of you have the number of that writ appeal. Every
we-
time we have a reference.
Not in this case, we have mentioned in other case, I forgot it, Your Lordship.
Which year? By the way, which year? 1819?
It should be around that time, Your Lordship.
No, just a minute. The judgment which Ms. Dinari was referring to regarding the state,
Yeah, state.
that was decided.
affidavit, Yes, yes.
No, that was decided in which year?
They're just saying that the appeal is pending before such and such. No, it's not mentioned the case number.
Okay. Is that all?
Yes.
Yes, Your Lordship.
Only
That is
one
my
point,
limited
Your
submission.
Lordship, as my learned counsel state that the revenue tax can be levied on those who are asking for the measurement of their land beside the land acquisition. So you have not agreed on that. So you have said that this act cannot be applicable to this instant case because this instant case is acquisition process. As you know, Your Lordship, over my land, the road is constructed. So we have not paid the compensation. We have approached this honorable court. So they should pay my compensation because they have constructed road. So as per law, the district collector constitute the team and verified and all this thing was done. So this is different thing. So the law says that those who ask for the land, verification, survey, measurement, they have to pay a tax from the value of the land. That is the law. That is their act. So this can be applicable to us. This is my.
Okay. She's right. Heard Ms. Dinari T. Azu, learned counsel for the petitioners, Ms. Zaram Sangpui, learned CGC for the respondent Union of India, Ms. Lal Nunlui, learned government advocate for the state respondents, and Mr. Lal Fakoma, learned counsel for the respondent MADC. Hearing concluded, judgment reserved.
Item number 5.
Yes. What is this matter?
Lordship, this is again a make appeal.
Why is it listed today?
Lordship, since notice has been issued to the respondents and LCR has been already arrived. However, Lordship, counsel for the respondents are absent due to the death of his junior, Mr. Kelchan Ninas Jr.'s father died today. So they were absent. Maybe
How many respondents are there?
respondents altogether 8. Lordship. And he's representing 1, 2, 4.
1, 2.
4. 1, 2, 3, and 4.
Who is representing?
Mr. Kelal Chandiana.
Kelal Chandiana.
Lordship, yes.
Okay. And then remaining?
Remaining, Lordship, in the IA, in the application for condonation of delay, we have issued notice to them, but they didn't appear. But in the main,
So paper book will be required or not?
paper book, Lordship, it may not be required at this stage because LCR is arrived.
Okay. Mr. Johnny L. Tochong, learned counsel for the appellant. Stop. It is submitted at the bar that on account of some bereavement, the counsel for respondent numbers 1 to 4, Mr. Lalchan Liana Kyangte, is not able to appear before this court today. Stop. As for respondent numbers 5, 6, 7, and 8, Mr. Johnny L. Tochong, learned counsel, submits that notice had been sent, served or sent?
Sent, Your Lordship.
Had been sent to the said respondents in the application for condonation of delay, but no one had appeared. Next para. As paid for, list the matter again after
2 weeks, Your Lordship.
2 weeks.
Item number 6.
Your Lordship, I'm appearing for the state respondents. We have sought for the pairwise comments. However, we have not received it till date, Your Lordship.
How much time?
2 weeks' time may be granted, Your
Ms.
Lordship.
Dinari, for 2 weeks. As paid for by Ms. Lalnunrui, learned government advocate appearing for the state respondents. Further 2 weeks' time is granted to obtain instructions and to file counter affidavit. Ms. Dinari Tiazu, learned counsel, appears for the petitioners. Yes.
Much obliged, Your Lordship.
For hearing, item number 11.
Your Lordship, Mr. Lorem Tuonga, counsel for the appellant, requested me to make a mention on his behalf. This may be taken up after a week, my lord. He is in this post today.
Mr. Lalrem Kluanga?
Yes, Lorem Tuonga, counsel for the
Which respondent?
appellant, my lord. Item 11.
Oh, okay.
This
After?
hearing,
When?
after a week, my lord.
Okay. On the prayer made on behalf of Mr. Lalrem Kluanga, learned counsel for the appellant, list the matter again after a week.
Item number 13.
And
My
what
lord,
is this?
this may also be taken up after a week. This is NDNPS appeal.
Appeal.
Appeal, yes. Regarding NDNPS case.
Okay, what is to be done? Any paper book required and all that?
Paper book has already been prepared, my lord. Now
Oh,
it
I
is
see.
ready for hearing.
Oh, I see. As paid for by Mr. Bilal Ramenga, learned counsel for the appellants. This is the matter again after a week.
Much obliged.